TV on these afternoons. Now, we talked about there being a lot of changes here in 2022 on Court TV. One of the changes is that plea day has been added to the afternoon of these miscellaneous dates. Now, plea day, as we call it, some people call it arraignment if you're in a different part of the country, some people call it arraignment here. That's really the first time someone is in court. Now, on plea day, you're going to see it's going to go very fast. The plea day part will go very fast. You're going to have people who haven't hired a private lawyer or are assigned to the public defender. If someone has hired a private lawyer by that point, that lawyer is going to file a waiver, what we call a waiver of arraignment, and a not guilty plea. So, for instance, that's what I do for my clients. My clients aren't going to go to plea day, but when I was a public defender, all of those clients go to plea day. It's a lot of times it's the first time a public defender is going to see that client. They're going to give them a card, they're going to set them an appointment, and they're going to get ready for that next court date, which is pretrial conference that we talked about in another video. This is a change because plea day last year was on a different day. It wasn't intertwined with this. This has actually streamlined it, put it all in one day. It does seem like it's a lot easier to take care of. After the plea day part goes, and that part goes rather quickly, then starts the afternoon of the miscellaneous VOP court date. The afternoon is reserved for larger hearings or contested VOP hearings, and I know we talked about those earlier. There's not a lot of those, but they do happen. But those other larger hearings, things like sentencings, when someone has entered a plea to a case, and now they're going to come back and get sentenced by the judge, and they're going to bring in, people to testify. They're going to bring in their friends or family to speak on their behalf and bring in letters, and we're going to hear that compelling testimony about maybe why they should get less than what the state's offered or why they should get this or that. And those are always very, very entertaining, very riveting to watch. I know even here at the office, we stay glued to Crestview Community TV on these afternoons.
He's an inmate.
Okay. Michael Matthews.
You've seen this one as an inmate?
William, we did, I believe.
Sorry, never mind.
Brandon, and it's
Merjuya.
Thank you.
So he, I believe, if I'm not mistaken, he's on the inmate list. Yeah.
Okay, so we'll wait on that.
Yeah, sure. That's going to be, the case is actually no prost, so.
Okay, we'll bring him out and talk to him. Keita Nicholson. Ms. Nicholson, come on down. 23 CF 1282.
Back on the one, no frost, he has been transported back already.
Good, thank you. Ms. Nicholson, does the state have an offer for Ms. Nicholson?
Judge, the state has not made a final determination in this case yet. We're still looking for victim inputs.
Okay. Ms. Nicholson, and has information been filed? No. Ms. Nicholson, information hasn't been filed against you So I need to reset it. How far out should I set it to this?
When is the next arraignment docket date?
It is July 20th.
Perhaps it could go a little after that.
Okay, August 17th.
That works.
So Ms. Nicholson, I'll see you back here on August 17th, okay? And then we'll give you a copy of the information. Thank you, ma'am.
1:30?
At 1:30, yes, ma'am. August 17th at 1:30. Thank you, ma'am. Mr. Patel, Sandapuku. How do you pronounce your first name?
Sandeep Kumar.
Good, thank you, sir.
Thank you.
Interesting charge against Mr. Patel. So is the state of Florida going to prosecute that? Is Mr. Patel, somebody tell me how we do
Generally
that?
speaking, no. I'm gonna be honest, when I went into the jail, normally if I see a fugitive from out of state, and I see a release date, normally it just means that they've been transported to that state. So I saw that, and to be honest, I thought that he had been transported. Because I know generally speaking, at first appearance, when we have the fugitive, they have an opportunity to either waive any sort of hearing, or they agree to it, and then that county or that state is contacted to come pick them up. I don't know what happened at first appearance with respect to that. Is he contesting his fugitive status, or?
Well, let's say that he is not. What does that mean?
I mean, ideally, if he wasn't contesting his fugitive status, then ideally he would have remained incarcerated until the state, I believe in this case, if I'm not mistaken, it was Kentucky, came and picked him up.
But he's out.
Right, and so that's why I'm like I fully did not expect him to be here today. So I'm very confused as to how that happened, because generally speaking, we don't let somebody out on bond if they're a fugitive from justice.
Right.
So Judge, if
You want
possible.
to continue, isn't it? Do we
No.
get an information on
No,
that?
that's the whole thing, yeah, because it's not really like a statute.
We just want to continue Mr. Patel's
Yes.
case for about a month?
Yes. And,
Mr. Patel, I didn't want you to say anything that may hurt your case, and so that's why I didn't ask you anything, but I wanted you to hear, I'm just as perplexed as the state. I've never seen that before. So again, I don't want to say anything or ask you to say anything that'll get you in trouble. So I'll see you back here on this on August 17th at 9 o'clock, okay? If Kentucky, if you have something going in Kentucky and you want to handle it with them, then it may drop off of my docket. If you don't, then the state will figure out what's going on between now and then. And I'll see you then.
9 o'clock or 1:30?
I'm sorry, 1:30.
If you'd like to say something, but
Yes, sir, just know that everything's being recorded and you use the
Okay, sir. It's happened whatever is like our Kentucky, I paid everything. And like our Kentucky state, dismiss the warrant, and like our best wife, Okaloosa, like our county sheriff department released me, and I have all the documents whatever I got paid and from like our Kentucky state.
You want to see what you have?
yeah, because if I can just get some verification of that warrant, please.
So just hold tight, let's see what goes on. And just so you know, the folks in the audience are doing the ones that say, the defendants that don't have attorneys first, and then the gallery, and then come back and ask for the public defender to call the cases. People that are in the gallery, and then we'll do the
So I just want to make sure that I'm clear on the record. So based on the documents that were just handed to me by Mr. Patel, it does appear as an order to dismiss was filed on the 14th of June 2023 out of the Commonwealth of Kentucky. Based on that, in that order, it specifically states that Mr. Patel is hereby dismissed without prejudice and all fugitive and complaint warrants be rescinded that were issued in Walton County, Kentucky. Given that information, Your Honor, the state would announce a dismissal of the out-of-state fugitive charge against Mr. Patel.
Mr. Patel, your case is dismissed. Thank you so much. Thanks for bringing in the people.
So I need this paper or not?
No, sir, you don't have to come back at all. Thank you, sir. Jesse Roundtree. Who's Roundtree? 23 CF 1212. Does the state have an offer from this Roundtree?
Sorry, I'm pulling something out.
Ms. Roundtree, I'm just asking you what their offer is to you, and set a time served, what point did you drop it to the downside of that, and so I want you to know, you may want to accept it without an attorney. They say they want to put you in jail or something, then I'm going to ask you if you want to. Okay.
Sorry, they're just loading right now. The offer that has been made by ASA Davis is an adjudication of guilt, probation for 36 months, restitution in the amount of $1,006. Court costs are in the amount of $615. There's a PD fee, 24 hours of community service, no contact with the victims, Aisha Roundtree, no trespassing at Whispering Pines, maintain gainful employment, if not gainfully employed, complete 5 applications per week, and complete an anti-theft course.
Ms. Roundtree, have you ever been on probation before?
No.
You want me to appoint a public defender to qualify financially? You want an attorney? I'm sorry,
I mean, I don't need a lawyer.
can't understand.
I said I don't need a lawyer. I was going to take the probation of the office.
You're saying you want to take the offer from the state?
Yeah.
Okay. So you'd be on probation for 36 months.
That's fine.
Rather do that than pay $150 and have an attorney represent you, talk to the state. Can't guarantee you the state wouldn't withdraw the offer like traditional way done. So you would accept it on attorney negotiate with the state, try to get it down. If you've never done probation, I just hesitate. Have you ever been convicted of a felony in the past?
No.
So you would be a convicted felon if I accepted this bill. But just to have a downside to you, Ms. Roundtree, I really recommend you get an attorney. Can't force you to get one, but you're taking on a lot to be a convicted felon, to be on probation for 36 months.
I'll take the attorney on.
How much money do you make per month?
Well, I make $17 an hour.
So you can do average maybe.
After taxes or before? Probably like, I'd say 35.
After I went through all that, you're probably not going to qualify for the money. You can put all the financial affidavit if you want one. That costs you $50. You can accept the state's offer, which is another waiving your right to a trial by jury. You're also waiving your right to an attorney. You want to accept that?
That's fine, yeah, I'll take it.
You want to waive your right here? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
So do you understand that the charge is providing a false identification of another person, and that's why you're here?
Yes, sir.
Take it to the state. stopped writing when it was 36 months probation. So
Oh, okay.
the rest of the term.
Yes.
So an adjudication bill, 36 months probation.
Pulling up to that for you now. 36 months probation, $615 in court costs. It is $1,006 in restitution being payable to Aisha Roundtree. That is Ayeesha Roundtree, Rountree. No trespassing at Whispering Pines. Maintain gainful employment, and if not gainfully employed, complete 5 applications per week, and complete an anti-theft class.
So, Mr. Roundtree, and in addition to what the state has stated, there'd be a $40 per month cost of secret fee. So here's what I thought. If you want to accept the state's offer, you'd be waiving your right to a trial by jury, waiving your right to an attorney. You'd be adjudicated guilty of felony. You'd be sentenced to 36 months probation. You have to pay $615 in court costs, $1,006 in restitution, and a $40 per month cost of secret fee. No trespassing at Whispering Pines, taking an annual theft course, and either obtaining gainful employment or show proof of that to a probation officer, or perform 5 applications or submit 5 applications per week. Is that what you wish to do? So after I do accept your plea, and that's what your sentence is. So probation is back in the first row, after they take your fingerprints and they'll call it probation. Jeffrey Shanklin is next. Jeffrey Scott, oh, he's incarcerated, I'm sorry. Azir Timms. Azir Ben Dan Timms. Let's see, Mr. Timms. Richard Williams, 23 CF 1259. Hello, Mr. Williams. Good, how are you? Yes, sir, we'll find out, right? To the state, any offer to Mr. Williams?
Yeah, sure.
And Mr. Williams, if it's incarceration or something like that, you can stop at that point. You don't have to go for everything else, because hopefully then Mr. Williams will want to do it.
Your Honor, there's a twofold offer. One of them is incarceration. It is either an adjudication of guilt with 180 days in the county jail, or an adjudication of guilt with 2 years of probation, $615 in court costs, PD fee, a substance abuse evaluation within 30 days, and to begin any treatment within 60 days, and then maintain gainful employment.
Okay, so both of them are an adjudication of guilt.
That's correct, Your Honor.
Has Mr. Williams ever been convicted of a felony? Mr. Williams, have you ever been convicted of this? Okay. Do you want me to appoint a public defender if you qualify financially? You're going to represent yourself or hire a private attorney? Or are you going to accept the state's offer?
What's the offer?
The offer is either 180 days in jail or 2 years probation.
I'd say 2 years probation.
Have you ever been on probation before?
Yes, sir.
Okay. If you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. So, Mr. Williams, you'd be a convicted felon. Do you understand that?
Yes, sir.
You'd be waiving your right to a trial by jury and your right to an attorney. Do you understand?
Yes, sir.
Now, let me get the rest of the terms from the state. 2 years probation, guilt.
Yes, $615 in court costs. Substance abuse evaluation within 30 days and beginning recommended treatment within 60 days with random UAs. And then maintain gainful employment. If not gainfully employed, complete 3 applications per week.
So So 3 per week, not 5, huh? Okay.
I'm just reading off the offer.
And then there'd be $40 per month cost of supervision.
That's correct, Your Honor.
Okay, so here's what I hear, Mr. Williams. You'd be adjudicated guilty of a felony. You'd be sentenced to 2 years probation. You'd have to pay $615 in court costs. Submit to a substance abuse evaluation. You have to go to an expert, and they will determine whether you needed any substance counseling. If they say yep, then you have to start that within 60 days from today and successfully complete that. Submit to random urinalysis, show proof of gainful employment, or perform 3 job searches per week, and you have to pay the $40 per month cost of supervision. Is that what you wish to do?
Yes, sir.
Do you have any questions for me or the state?
No, sir.
Mr. Williams, that's what your sentence is.
And misdemeanors, time served? or-
Yes, Your Honor, we do misdemeanors credit for time served.
Okay. So that just means the misdemeanors are gone. The 2 years probation is just on the felony. And if you'll
Mr.
see.
Williams, this way. Okay, just relax your hand.
Johnny Ray Young, 23 CF 1302. Hello, Mr. Young. Doing well, how are you?
Awesome.
Does the state have an offer for Mr. Young?
Yes, sir, let me pull it up. Sorry, Judge. The offer, this is going to be an incarceration offer of 13.2 months in the Department of Corrections, adjudication of guilt.
Okay, let me stop you there. Mr. Young, do you wish for me to appoint the public defender if
Yes,
you
sir.
qualify financially?
Yeah, I don't have a job.
Okay, how long have you been unemployed?
3 weeks.
Okay, how much were you making per month before that?
Making $12 so probably $2 a month.
Okay, I do appoint the public defender to represent you. Mr. McKinney's approaching on your right.
Jason McKinney on behalf of Mr. Young Jr. We would acknowledge the 3-count information, waive its formal reading and plead not guilty. This is scheduled for September 11th at 9 a.m. for pretrial.
Mr. Young, I'll see you back here September 11th at 9 o'clock. Stay in touch with Mr. McKinney. Thank you, sir. Now to the PD, you know the folks that are in the gallery?
Here I have William McLeod. Your Honor, this is Mr. McLeod. We do have a 2-count information. We would waive the formal reading, enter the not guilty plea, and ask that this remain set on the September 11th docket.
Mr. McLeod, I'll see you September 11th at 9 o'clock.
Thank you, sir.
Thank you, sir.
Amanda Pitts. Your Honor, I have only one more who's going to be out of custody, and she called my office and said she's on the way from Mobile. She should be here any minute. So,
Good, thank you. Mr. McKinney?
Judge, I have Jamarat Hendricks, followed by Stephen Spradlin. Mr. Hendricks is present in the courtroom in a white shirt. He's here today in case number 23 CF 1260. We would acknowledge the receipt of a 2-count information, waive its formal reading and a plea of not guilty. This is scheduled for a pretrial date on September 11th at 9 a.m.
Mr. Hendricks, I'll see you September 11th at 9. Okay? Stay in touch with Mr. McKinney. Thank you.
Judge, also have Mr. Spradlin. Spradlin.
Oh, Mr. Spread.
Judge, Mr. Spradlin is here
In 23 CF 742, is there an offer from the state? I see that this is a possession of controlled substance related to methamphetamine.
I'm trying to find the offer. Yeah, he unfortunately squares guidelines. However, if he is amenable to it, he scores 16.28 months in the guidelines. However, Brooke had mentioned on this offer sheet that she would be amenable to drug court. If that is something that he would be interested in, then I would recommend us setting it for the September 11th. I will message Terry Henderson sometime this afternoon when I get some time and tell her that she needs to meet with Mr. Spradlin. That'll likely be what they'll have to do, Jason, is she'll probably have to get into contact with you since he's out of custody, if that's something you guys want to do.
In those situations, I always ask for client to make an appointment to come and meet with me so I can discuss what that program is, what to expect walking in the door. All I'm going to do is enter three numbers today and then maybe come talk to me.
Mr. Spradlin. Mr. Spradlin, hold on 1 second. Really think about drug court. Listen to Mr. McKinney, because they have a lot of tools that the circuit court, that my court doesn't have. They'll really stay on you. They look over your shoulder a lot, but it's a really good program, so consider it. Okay?
I consider it.
Thank you, sir.
Can I talk to you? And we'll talk.
I have Jared Weber, also in the courtroom. Mr. Weber is approaching in blue shirt.
I'm just going. Good, how are you?
And Judge, I would acknowledge the receipt of 3-count information, waive its formal reading in a plea of not guilty in 23 CF 1249.
Mr. Weber, I'll see you on September 11th at 9 o'clock.
This is a situation that if we reach an agreement ahead of that court date, can I add this on to an earlier document?
Absolutely. Yes, sir.
Judge, those are the matters that I have that are out of custody.
Okay. Any other defendants in the gallery, or are y'all waiting on folks that are incarcerated? Yes, ma'am?
I think that we got here right after you called with me, Michael Matthews.
Okay, come on down. Yes, sir.
No. That was Weber.
Mr. Matthews?
Yes, sir.
Good. 23 CF 1257. Does the state have an offer for Mr. Matthews?
It's Leonard, Your Honor, I'm sorry.
Mr. Matthews, was that your mom that spoke up earlier?
Yes, sir. Yes, sir.
She keeps looking out for you, right?
Oh, yeah. Oh, yeah.
So, Your Honor, this is going to be either a probation or a PTI offer. Either way, the terms would be similar. The terms of either the probation or the PTI would be 24 hours of community service work, a substance abuse evaluation, and treatment recommended, and that's mainly because of his age, we want him to get some education on cannabis consumption. Eligible for early termination upon completion of those requirements. The PTI would be a 10-month PTI. As long as he goes through that, the evaluation and treatment, and then as well as the 24 hours of community service work, then that case will be dismissed.
Okay. And how long would the probation be?
The probation would be 2 years, standard probation, and it would be a withhold if we did the probation.
Okay. So, Mr. Matthews, sifting through that, the state's offering you a pretrial intervention, which is basically a contract that says if you fulfill the terms of what they tell you that you need to do for 10 months, don't get in trouble, maybe community service hours, other things that they have, and you'd have to talk to them and they give you a written agreement, asking questions. You decide whether you want to enter into that or not. I'm not going to ask you today. But at the end of that, if you do it, your case is dismissed. And so you never have to look over your shoulder and worry about it. They're also offering you 2 years of probation. I would strongly suggest that, you know, I can appoint an attorney to represent you, but what I'd recommend is that you talk to pretrial intervention between now and November 11th. And then you decide if you want to enter that. If you want to enter that, you can sign the agreement for September 11th. And then your case will fall off the docket. Your mom can certainly talk with pretrial with you, and then you can decide if it's in your best interest, okay? So I'm going to just enter a denial for you, set you for September 11th at 9 o'clock. But talk to Mr. Gomez about.
I need his email and the phone number. If you should probably come over here and get that.
I'm just giving your email and phone number. They'll send you that information, look at it. You decide that you don't want to enter a pretrial intervention, and you want an attorney, you can file a financial affidavit with the clerk, but really look at pretrial. Okay? Thank you, sir.
Thank you. Put this right here, email and phone.
Just stand up right here and be ready for when you walk out.
I'm going to be checking for your email and we'll get that agreement to you. Yes, sir.
Mr. Matthews, so just for the record, you're charged with possession of a controlled substance without a prescription, and the paper that they just handed you is the information, it's the charging document where the state's charging you with that crime, okay?
Okay.
Thank you, sir. Yes, sir. What's your name?
Tyler Smith.
Thanks, Mr. Smith.
I showed that a not guilty plea was entered on his behalf by Katie Jacobit.
Okay. So you're represented by Ms. Jaquith by the Regional Conflict Council. Okay, she entered a denial. He set for September 11th. So I'll see you on September 11th at 9 o'clock. If you want to avoid about 280 people, if the state offers you something that you think's in your best interest to accept it, then Ms. Jacob can set it for a hearing before September 11th.
Okay.
Okay? Thank you, sir.
Thank you.
All right, is there anyone else in the gallery who's,
Yes, sir. Come on in. Yes, sir. What's your name?
Eric Paget.
Paget?
Yes, sir.
Please, Mr. Paget. Mr. Klein, do you represent? Mr.
No, Your Honor, we had emailed the clerk's office yesterday. We were put on the case improperly, and so they removed us.
Okay. Mr. Paget's case number is 23 CF 1233. Does the state have an offer from Mr. Paget?
Yes, Your Honor, I'm pulling it up real quick.
So, Mr. Paget, while he's looking, you're charged with possession of a controlled substance without a prescription. Does he have any information? Yes.
I believe there's also this, Your Honor, this offer that I'm about to give encompasses, there's also a 23 CT 1394 case. So that way, if he would like to resolve everything at one time, he can. On the possession of controlled substance in 23 CF 1233, we would be offering an adjudication withheld on the felony, so that he's not a convicted felon. Standard 2 years probation, $615 in court costs, 24 hours of community service work, and a substance abuse evaluation and treatment recommended. On the DUI, that would be an adjudication of guilt. It's a misdemeanor. 476.13 in court costs, $500 fine, $50 cost of prosecution, 1129 probation, that would be run concurrent with the felony probation, 50 hours of community service work, 6 months driver's license suspension, DUI school victim impact panel, and 10-day vehicle impound. Now, I do want to let him know he does not have to do anything with that misdemeanor DUI case. If he doesn't want to, he can just take the felony offer of a withhold and 2 years of probation if he wants to do that today. I just wanted to give him the option, if he wants to resolve all of his cases at one time, to go ahead and do that.
Mr. Paget, that's a lot that he said.
Yes, sir. Would the offer stand? I would like to speak with my attorneys.
Absolutely.
And then can we move forward at that point?
Yes, sir, I can't tell you, I can't make the state hold an offer open.
The felony offer will remain open.
Okay,
So,
yes, sir. Who's going to represent you?
Powell
Okay,
Law Firm.
yes, sir. So then I'll see you back here on November 11th at 9 o'clock. I'm sorry, I keep saying September 11th at 9 o'clock. Talk to Mr. Powell. He'll get in touch with Mr. Gomez, and Mr. Gomez can tell him what that offer is. If you want to enter it before those 280 people show up on September 11th, then we can set a hearing before that day. Thank you, sir.
Thank you so much.
Yes, sir. Okay, is there, do we want to do, is that the arraignment?
That is a docket day, he's already had arraignment
Okay, so you still have to appear in front of Judge Mason
on August 14th at 9 a.m.
August 14th at 9 o'clock. Okay, so don't miss that.
Yeah, I got that. Thank you.
Good, thank you, sir. Thank you, ma'am. And then the inmates, or I'm sorry, you're a defendant? Come on, down. What's your name?
Amanda Pitts.
Your Honor, this is Amanda Pitts. We do have, and we'll acknowledge receipt of the 3-count information. We will waive the formal reading, enter a not guilty plea, and ask that this remains set on the September 11th docket.
Okay, Ms. Pitts, I'll see you September 11th at 9 o'clock, okay?
Okay,
Thank you, ma'am.
thank you.
Are y'all here for an inmate?
Yeah, man.
Who are you here for?
Shanklin,
Shanklin?
Jeff Shanklin.
Awesome, thank you.
Yes, ma'am.
And I see that Mr. Lozzi has zoomed in. Is he present at 2:30?
He's on the 2:30 docket?
Okay.
Your Honor, Mr. Losey is currently at Blackwater Correctional Institution.
You want to bring him up now?
Please, since he's here, yes.
Good. He's trying. It says joining, but it hasn't opened yet. Why don't we go ahead and do that?
That's fine, Your Honors. However the court wants to handle that. This will be brief with Mr. Losey.
As soon as you see him pop up, let me
Yes, sir.
We'll take the next one. Yes, ma'am.
Awesome, Courtney Patterson?
Thank you. Come on, Ms. Patterson.
Your Honor, this is Kelly Patterson. We do have a 2-count information. We will waive the formal reading, enter a not guilty plea. Leave this on the September 11th docket. I was just explaining to Ms. Patterson. I'm going to be up at the jail to see her the next time I go. There's a pretty decent chance you might see her next week or sometime before September 11th.
Excellent. Good, Ms. Patterson. Hopefully I'll see you before September 11th. If not, I'll see you on the 11th.
Yes, Your Honor.
Thank you, ma'am.
Thank you so much. Next is Andrea Wade.
Judge, this is Andrea Wade, on court in 23 CF 1263. Did you read this? Are you still?
What was the name? I'm sorry.
Wade, Andrea Wade, 23 CF 1260.
Judge, we have reached an agreement. Ms. Wade would be entering a plea as charged. The agreement calls for an adjudication of guilt. Ms. Wade has previously been adjudicated of a felony. And the terms are for time served with $615 in court cost, $150 cost of defense. May I approach the plea agreement?
Yes, sir. Thank you. Ms. Wade, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down. Ms. Wade, did you read the plea agreement?
Yes, sir.
Do you understand?
Yes, sir.
Did you sign?
Yes, sir.
Ms. Wade, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. You need to pay the $615 in court costs, $150 public defender's fees. So how long do you want before that goes to a civil lien?
Judge, may we ask for 6 months?
Yes, sir. So if you fail to pay it within 6 months, it'll go to a civil lien or judgment.
Okay.
Thank you, ma'am.
Ms. Wade, where are we? This one's the warrant.
It's going to be Mr. Shanklin.
Shanklin.
It will be served downstairs. Okay.
Yes. Come on, Mr. Shanklin. Go ahead.
There's a warrant for this. Thank you.
Hello, Mr. Shanklin.
Hi.
Mr. Shanklin, just for the record, it's 23 CF 1266. Does the state have an offer for Mr. Shanklin?
No.
Sorry.
No.
Mr. Shanklin, so I'm asking the state if they have an offer for you. If you decide you want to take it, we'll talk about it. If you say, if they offer you jail or something like that, or prison, then I'll ask you if you want to return.
I'll ask you.
Your Honor, at this time, the offer is an adjudication of guilt, 2 years of probation, $615 in court costs, PD fee, no, never mind, don't scratch that. Substance abuse evaluation within 30 days and beginning recommended treatment within 60 days, 24 hours of community service work.
Okay, and then it'd be $40 per month cost of supervision. Okay. So, Mr. Shanklin, have you ever been on probation before?
Yes, sir.
Have you ever been convicted of a felony?
Yes, sir.
So what the state's offering you is an adjudication of guilt, 2 years probation. That would run concurrently on each count. It's a felony, and it'd be time served on misdemeanors.
That's correct, Your Honor.
Okay. So 2 years probation. You'd have to pay court costs of $615, submit to a substance abuse evaluation within 30 days from today. If any treatment's recommended, then you'd have to do that treatment. You'd have to perform 24 hours of community service work and pay $40 per month cost of supervision. If you want to do that, you'd be waiving your right to an attorney. You'd be waiving your right to a jury trial. I can appoint an attorney if you wish for me to appoint one, and you qualify financially. It's up to you.
I think I'll take what the state is offering me. Let me just, so he's offering me 2 years probation from today forward, right?
Correct.
With a substance abuse evaluation
Correct.
and to pay the fines.
To pay the court costs, there aren't any fines, court costs, $40 per month cost of supervision, perform 24 hours of community service.
Yes, sir.
Yes. You'll raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
So help me God. Yes,
You
sir.
Put your hand up. So, Mr. Shanklin, you understand that you'd be waiving your right to a trial by jury?
Yes, sir.
And do you understand that you're waiving your right to an attorney?
Yes, sir.
Have any questions for me or the state?
I do. Are you the drug court that's on Wednesdays at 4:30?
I am not. That's Judge Ward.
Ward, okay. That's all, the only question I have, sir.
Mr. Shanklin, I do accept your plea. You're adjudicated guilty. You're sentenced to 2 years probation. You need to pay the $615 in court costs, $40 per month cost of supervision. Submit to a substance abuse evaluation within 30 days from today. Begin any treatment if it's recommended within 60 days from today. Perform 24 hours of community service work. Okay?
Yes, sir.
Thank you, sir. When you get out of jail, if it's before 5 o'clock, you need to report to probation. If it's after 5 o'clock, you need to report tomorrow morning at 8.
Okay. And I'll be here in Fort Walton.
Where do you live?
Well, I'm in Fort Walton, but they're going to let me out in Crestview, and I guess the bus, they have a bus that runs there, but it quits at 5:30
Okay, where do you live?
in Fort Walton.
Okay, then you should report in Fort Walton.
Okay.
Okay?
All right. Thank you, sir.
Yes, sir. Thank you.
Thank you.
Then Bert is on Zoom. Is Mr. Bert?
He's at 2:30, Your Honor. He's on motion for return of firearms.
He's a motion to fire his attorney? Is that what?
No, a motion for return of firearms.
Oh, okay. Okay. Okay, the other anything? Thank you. So, Mr. Kelly.
Good morning, Your Honor.
Good morning. Good afternoon.
Judge, Mr. Malaby is currently unrepresented. He is currently charged with using a computer to facilitate or physical sexual conduct of a child, unlawfully situate a device, and giving obscene material to a minor. Given that he has a prior sex offense and with a child with criminal history, we are seeking significant prison time. So perhaps the court would like to inquire about public defender
Yes,
services.
Mr. Malaby,
Yes, Your Honor.
do you wish for me to appoint the public defender if you qualify financially?
Yes, Your Honor.
How much money do you make per month?
When I was working, I would be making around $2,600 a month.
Okay. How long have you been incarcerated?
A little over a month now, sir.
And what's your bond?
$52,000.
Okay. I'm just trying to figure out if he's going to be able to get out or not. Mr. Malaby, what I would say at this point is fill out a financial affidavit for the public defender's office. Let the clerk look at that. If the clerk denies you and says that you don't qualify, appeal it to the judge, because the court has a little more discretion than the clerk does, and let us look at that. You're really close to that amount, load it up with expenses or whatever you've got that's truthful, and let the court look at it, okay?
Yes, sir.
I'm not appointing an attorney at this point. If you don't qualify for public defender, then you'll either be representing yourself or you'll have to hire a private attorney, okay?
Yes, Your Honor.
I'll see you back here on September 11th in the afternoon.
Yes, Your Honor. Thank you.
Thank you, sir.
Next is Joseph Middleton.
And that concludes my motions for the day. Have to be excused.
Yes, ma'am, thank you.
You got to dismiss from those seats.
You want to do Mr. Losey next?
As soon as he's connected.
Middleton, come on through. Go straight to the left.
Sir, 23 CF 1290. Does the state have an offer for Mr. Middleton? Mr. Middleton, what I'm doing is asking the state if they have an offer for you. If they offer you something that you want to accept without an attorney and waiving a trial by jury, then you can do that. If you don't want to accept the state's offer, I can appoint a public defender if you qualify financially, or you can certainly hire a private.
Yes, sir, if that's acceptable, that would be fine.
Your Honor, this time the state's going to be making an incarceration offer of adjudication of guilt in 24 months, Department of Corrections.
Okay. So, Mr. Middleton, the state's offering you a prison sentence. Do you want me to appoint a public defender if you qualify financially?
Yes, sir, please.
How much money do you make per month?
I'm unemployed.
How long have you been unemployed?
About 8 months.
Okay, I do appoint a public defender to represent you.
Your Honor, if I could have a second with Mr. Middleton.
Yes, sir.
Your Honor, we'll go ahead and follow this up, but we're going to have to move to withdraw from Mr. Middleton. He has mentioned your name in Ms. Patterson's police report. So we'll follow this up with a formal motion and order. But I think to speed things along, the court should relieve our office today and appoint RCC.
I do grant your motion to withdraw, and so I appoint the Regional Conflict Counsel. Ms. Jakewood is that attorney. She'll get an order, and then she'll come see you in the jail. And I'll see you back here. You were just handed an information, the charging document that says that you're charged with illegal use of a credit card 2 or more times in 6 months.
Yes, sir.
So I'll see you.
I can't hear you.
I'll see you on September 11th with Mr.
Hello?
Yes, sir. Mr. Burt, can you hear us? Mr. Burt? Okay, I'm muted, Mr. Burt. Okay, thank you, sir.
Yes, sir.
Those of you on Zoom, I'm finishing the folks in the courtroom, and then we'll talk to you. Lucy hasn't appeared.
He's right there.
He's on, he's just muted right now.
Okay. Lucy's under, got it. Okay, good. Mr. Lucy. Mr. Lucy, if you'll unmute your mic. Mr. Lucy, if you'll unmute your mic. Good. Thank you, sir. Mr. Lyons.
I talked to Mr. Losey yesterday, and Kirk, if I say anything incorrect or you change your mind, just let me know. But I talked to Mr. Losey yesterday about his motion to withdraw the plea. I believe that Mr. Losey wants to withdraw the motion to withdraw the plea, but I wanted him to stay on for today's docket so the court could inquire directly of Mr. Losey. But that's pretty much it.
Okay, hold on one second. Mr. Lucy, how are you doing?
Good, Your Honor, thank you. And how about yourself, sir?
I'm doing well, thank you, sir. So, Mr. Lucy, you want to withdraw your motion to withdraw a plea, is that correct?
That is correct, Your Honor.
Okay. After receiving all the information feel like it's not in your best interest to pursue that at this point?
Yes, sir. I would like to withdraw that.
Okay. Then your motion to withdraw is gone. So if you ever want to file anything in the future, then the court's here to help.
And Kirk, I talked to the state attorney this morning. As soon as I get that FDLE report regarding the DNA, I'll get you a copy in the mail.
I appreciate it.
Good luck, okay?
So when will I see Mr. Lindsay?
Hopefully next.
Okay, yes. Good. Thanks, Mr. Lindsay.
Yes, sir. I'd like to say thank you to you, to the court, Your Honor, and Mr. Kleins, and also Mr. Gomez. Thank you very much for your time.
Yes, sir. Thank you.
Butch Moger?
Moger.
Mr. Moger?
Your Honor, this is Butch Moger in 23 CF 1242. We do have a resolution to resolve this case. At this time, Mr. Moger would be entering a plea of no contest as charged. The agreed upon sentence is that he will be placed on 2 years of probation. He will perform 24 hours of community service, be assessed $615 in court costs, $150 in public defender fees, and he would be adjudicated. I'm sorry, no. It would be withholding of adjudication.
Okay. And then $40 per month cost of supervision?
Yes, sir.
Mr. Moger, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. So you can put your hand there, please. Mr. Moger, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Moger, I do accept your plea. Adjudication is withheld. You're sentenced to 2 years probation. You need to perform 24 hours of community service work.
Right.
Pay the $615 in court costs, $150 public defender's fee, and $40 per month cost of supervision.
Yes, sir.
Thank you, sir. Good luck to you. Yes, sir.
Yes, sir. Yeah.
Next is Dion Mount. What city? Never even. Okay.
No, Mr. Mount.
Your Honor, this is Mr. Mount. He does have a number of cases here. We're going to enter not guilty pleas on all of the information charged. I will tell the court we are trying to get this resolved as quick as possible for some kind of a plea into the Keaton program. So all we can do today is leave this set on the September 11th docket, but I've already talked to Mr. Gomez, and if we can get this back before the court much, much sooner, we will.
Good. Mr. Mount, I'll see you no later than September 11th. If your attorney sets a hearing before that date, I'll see you then. All right, thank you, sir.
Willie Patterson? Mr. Patterson? Here you go. And you're gonna go to the left.
Your Honor, this is Mr. Willie Patterson. He's in the same exact position Mr. Mount was. We'll enter a not guilty plea today, Your Honor. There's a 2-count information. I believe the formal reading. Leave it on the September 11th docket, but again, he's already been accepted to Keaton, so the state just has to make some Marcy's Law phone calls.
Okay, good. Mr. Patterson, I'll see you no later than September 11th. Okay? Thank you, sir.
Dexter Pearson Jr.
Your Honor, this is Mr. Dexter Pearson. There's three-count information. Waive the formal reading. Enter a not guilty plea. Ask that this remain set on the September 11th docket. I did talk to Mr. Gomez, and I believe the state's going to stipulate to reducing his bond to a signature bond and modifying the bond condition to no violent contact with the alleged victim.
That's correct, Your Honor. And I just want to put on the record, the basis of that is that the victim had submitted a drop charge request form. However, there is an independent witness. So given that there's an independent witness, we're not necessarily amenable to completely dropping the charges at this point. However, given that the victim has requested contact, that is the reason why we're stipulating to the no violent contact and to the signature bond.
So, Mr. Pearson, your bond is converted into a signature bond, and you'll have no violent contact with the alleged victim.
Yes, sir, Mr. Brown.
And I'll see you back here on September 11th at 9 o'clock.
I have a question. Did you get served a warrant this morning?
No.
You have a warrant.
Is it
A
felony?
VOP.
DOP? Misdemeanor or felony?
Misdemeanor.
Misdemeanor DOP?
Yeah, it will be served downstairs.
If you can we walk out.
Next is Charlie Rhodes.
Okay, thank you.
Mr. Rhodes. Just the lecture.
Come on, Mr. Rhodes.
Judge, Mr. Rhodes is before the court in a number of cases. If I go through each of them individually, we could be here for a while. But at this point of the proceeding, I'm going to enter a plea of not guilty to all of his charges, all of his counts. Mr. Rhodes is already under a federal sentence relating to a lot of the same events from the same set of facts. So I would ask the state to determine whether or not they're going to seek to move forward in state court since he's already under a federal sentence. I know I've had that discussion with Ms. Davis, who is the assigned assistant state attorney, but I did want to make record while we were here today. The next court date scheduled for Mr. Rhodes is going to be the 11th of September at 9 a.m. However, given that we already know the resolution of the federal sentence, if we can gain some ground or figure out where we're going on these cases, I'd like to schedule this to an earlier date if we have a resolution.
Absolutely. So, Mr. Rhodes, I'll see you back here no later than September 11th. Okay? Thank you, sir.
Anthony Taylor.
Thank you. Good, how are you?
Judge, Mr. Taylor is before the court today related to a two-count information. We are going to waive its formal reading, enter a plea of not guilty. This is scheduled for September 11th for a pretrial court date at that time. I've reached out to the state to see if we could resolve this today. We were unable to do so. So I'm going to maintain the not guilty plea and ask for this to remain set on the September 11th court date.
Mr. Taylor, that means that I'll see you no later than September 11th, but hopefully the state will make you an offer that you think is in your best interest to accept. Mr. McKinney can set that for a hearing before the 11th.
Next is
This is yours.
Darnell Thomas is next. Mr. Thomas?
Judge, this is Mr. Darnell Thomas. Mr. Thomas is here in 23 CF 1314. Did you have a chance to read this? Is this Do you have any questions at all before you sign this? Judge, we're making sure that we're totally on the same page. Mr. Thomas has reached an agreement with the state. He has reviewed the plea agreement. We discussed what this was likely going to be yesterday, but he would need to execute the document at this time. He needs to sign it. Mr. Thomas is going to be entering a plea as charged. He's going to be adjudicated guilty. He does have a prior adjudication. He's going to be sentenced to time served. The court cost of $615 and a $150 cost of defense. We would ask for 90 days upon his release to pay the financials.
Mr. Thomas, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You put your hand up. Mr. Thomas, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Thomas, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. You need to pay the $615 in court costs, $150 public defender's fee. Those amounts will go to the civil lien or judgment 90 days from today if you fail to pay them.
Okay.
Thank you, sir.
Right over here, sir.
Next, Mr. Thompson.
Thank you.
Mr. Thompson.
Judge, this is Marcus Thompson before the court in 23 CF 1214. The state has filed a motion to transfer Mr. Thompson's case to another division because he has a case in front of Judge Ketchel. That case is scheduled for pretrial conference on August 16th, 2023 in front of Judge Ketchel. So for today's purposes, I will acknowledge the receipt of a 3-count information, waive its formal reading, and enter a plea if not guilty, but I do anticipate that this case is going to be transferred to the other division.
So, Mr. Thompson, you'll appear in front of Judge Ketchel on August 16th. Thank you, sir.
And Mr. Gates is going to be doing that for everything.
Next is Wolf.
This is Mr. Joseph Wolf. Mr. Wolf is before the court in 23 CF 1220. I believe that this is a 1-count information that's been filed. And we have reached out to the state and tried to resolve this today. We've been unable to do so. Mr. Wolf has engaged with the Veterans Court program. That may be an option for Mr. Wolf. He's already observed that court once. We're going to seek that end as well as other resolutions. For today's purposes, without an offer from the state, we would be entering a plea of not guilty to 2-count information. We would waive its formal reading. And this is scheduled for the 11th of September at 9 a.m. for a pretrial court date, but I would hope that we see some movement on it prior to that date to reach an agreement or for Mr. Wolf to enter into the Veterans Court program.
And you said 2-count information?
It is a 2-count information that's been filed.
What's the second count?
Count 1 is a 3rd-degree felony grand theft auto. Count 2 on what I'm looking at is a misdemeanor DUI that looks like was added.
Okay. Mr. Wolf, unless you're accepted into Veterans Court, and I hope you are, because they've got all kinds of different tools that I don't have. If you're not accepted into that, then I'll see you back here on September 11th.
And that's my last inmate
Thank you, ma'am.
for the 130.
For right now.
We're going to take a 5-minute break, and then we'll come back and continue with the afternoon topic.
All rise. Court's in recess.
Tested sentence.
We're on a 5-minute recess. We should only have 3 left after what we went through. Yes, sir, if you want to transport the others downstairs, you have. We're going to go straight to the service, please. We're not going straight to, we're going to the fastest first. So if, I think Jessica Smith will be one of the faster ones, since that's all over the cave. And then one of them is the attorney will not charge, and that is Errol.
Yeah, that's a good case to try.
The other one is we're going to do out of custody fastest service, so you jump up normally under that. I don't print off the 230 docket, so I let you guys tell me
That's
when. I kind of let the 230 just have at it.
Right.
Good for
No, so that is benefit of the use.
It's got tag, lights, PC stop seat. Yeah.
I would have to.
Does he ever have any lawnmower cases?
The Jays have nothing to do with that. That is.
It was, I can't remember the
Whoever
dude's
does
name.
that has a lot of time, it's different
Oh,
for us down here because we have.
It was, no sleeping there.
Ever.
15 no sleep. Justin had cases. I made dudes. I was like, oh man, I was drinking these phones at Apple. So, I know, I was like, oh yeah.
When you want to get a hold of somebody back there,
Savage ability, you know?
3-8.
Well, I was trying to 24 and then it's in the class. These were they were and then it was like
We talked about this morning, not.
3-8, you know, voting.
because that was just
Voting concept. I didn't know it was voting, just, yeah, 3-8. And then we're back there. Same thing.
All right, the judge is back around to the courtroom. Can we make sure our phones are on silent, please? Hey, Frank, I have no idea.
I got you. I'm listening.
All right.
Hello.
That's all I'm thinking. Come read your stuff if you want me to handle it.
figured as much. She does have to come off the street.
All rise. Circuit Court is back in session.
Mr. Burt, you've been on for a while. I thought I'd take your case next before I ask the attorneys. Give me 1 second, let me find your motion. Mr. Burt's case number is 19 CF 2880. Mr. Burt, you're seeking to have your pistol returned, correct? Mr. Burt, your mic's muted. I'll ask you to unmute. Mr. Burt, can you hear me? Good. Mr. Burt, can you hear me? Hello, Mr. Burt? Mr. Burt? Can you hear me? Apparently not. Okay.
I mean, he unmuted his mic, so you gotta think that he can. Mr. Burt, if you can hear us, can you please, just raise your hand or acknowledge Mr. Bill Burt?
I sent him a message that asked him to unmute his mic, so that was
Okay.
digital, so I don't think he can hear
Do you
us.
want to ask if he can hear us?
Is that fun?
Mr. Burt, can you hear us in the courtroom?
He's not.
It's officially on this side then.
Can everybody else hear us?
Yes.
Are we
Okay,
sure? Yeah. Okay.
so what case do we want to take next since we can't get Mr. Burt?
Your Honor, I have Douglas Levens, which. Michael Levens? I'm sorry, Michael Levens. Your Honor, this is Mr. Michael Levens. We had filed a motion to withdraw from Mr. Levens' case. However, in speaking with him, I believe he's retained private counsel, so I believe the motion, we can withdraw the motion.
Okay. Mr. Levens, who have you hired?
Flowerby and Merrifield.
Okay. Just get them to file a notice of appearance in your case. Am I going to see Mr. Levens on the 11th?
That's.
He's set for next Thursday for felony and plea day.
Okay.
What?
I just hired them this morning, so they haven't really had time to.
Okay. So I'll see you on
He's set for
Thursday.
7:20 for felony and plea day.
7:20.
Well, since
They did tell me dates are likely to change, so I'll be.
Since they haven't filed the notice yet, Your Honor, if the court would allow me to enter a not guilty plea
Yes.
on these 4 counts.
Good.
We have the information, there's a 4-count information. I'll give a copy of this to Mr. Levens, but then we want to come back to court next week. But if you let them know, yes, before we got off the case, we entered a not guilty plea for you.
And so I'll see Mr. Levens on September 11th at 9 o'clock.
All right.
Okay? Thank you, sir.
Thank you.
Your Honor, I think a really quick one, he's on Zoom, would be Tucker.
Okay, Mr. Tucker.
I don't know if you can hear me.
Mr. Tucker, can you, and is that Tucker Robinson?
Yes. I'm assuming that's what.
Mr. Robinson, can you hear us?
You might need to unmute your mic, Mr. Robinson.
I'll ask him to unmute it.
Can you hear me now?
Yes.
Oh, I can't. Yes, sir.
Your Honor, just to save the court time, I believe a motion for early termination of probation was filed in this case, and at this time, the state's going to stipulate to that early termination. He's completed all requirements of probation, and so the state would be amenable to terminating that.
Okay. Mr. Robinson, then your supervision is terminated, okay?
Thank you so much, Your Honor.
Thank you, sir.
Thank you. So do I need to call my probation officer or anything?
No, they're here and they're taking it down that your supervision is terminated.
Okay, all right, thank you so much.
Thank
Y'all have a wonderful rest of your day.
You too.
Bye.
Who do we want to take next?
Your Honor, I think.
Mr. Durrell, are you ready?
Yes, sir. Here.
Thank you, Your Honor. May it please the court, Dustin Durrell on behalf of Mr. Derek Wilson. Your Honor, Mr. Wilson had previously entered an admission to the violation of probation. This is the one we had set out for sentencing. Ms. Davis and I were trying to get the Haven House issue figured out. We have gotten everything figured out, and I have reduced everything to writing if I may approach.
Yes, sir. Oh, Mr. Wilson.
Hello, sir. So, Your Honor, at this time, well, Mr. Wilson has already actually admitted to the violation of probation. Per agreement with the state, we're going to reinstate and modify Mr. Wilson's probation, extend probation for an additional 7 months. That will give him enough time to complete the year-long Haven House program. The supervision will terminate upon successful completion of Haven House. We're asking for 45 days to check in because we're still trying to get the DUI, which served as the basis for this violation, under essentially the same agreement. Judge Mason has asked that stay in her court, though, so we weren't able to ask for stipulated jurisdiction and handle it all at once. I believe that's all.
And the adjudication?
See if it was previously withheld. Was it previously adjudicated?
Yes.
Thank you, Madam Clerk. Well, we'll continue with the adjudication then, Your Honor.
Mr. Wilson, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Thank you, sir. You can put your hand up. Mr. Wilson, so did you read the plea agreement?
I did.
Do you understand it?
I do.
Did you discuss it with your attorney?
To a point, yes.
Good. Okay. Do you have any questions for your attorney or the court or the state?
I don't think so, no.
Do you agree to everything that Mr. Durrell stated today on the record?
Yes.
Mr. Wilson, I do accept your plea. You're adjudicated guilty. Your prior supervision is reinstated with the original terms and conditions, but it's modified, so it is extended for an additional 7 months. You'll need to enter and successfully complete Haven House. You don't have to check into Haven House for another 45 days. Okay?
Okay.
Thank you, sir. I guess there's a $100 cost of prosecution, right?
Yes, Your Honor.
Okay. Thank you, Mr. Wilson. We elect you, sir.
Thank you.
Thank you, Your Honor.
Thanks, Mr. Brown. Mr. Gomez?
Do I use today or?
What do you wish to do? And I see that you got the doctor in the gallery.
Yes, Dr. McDonald's here.
You want to do that case?
Sure. There's going to be multiple witnesses in this case, Your Honor.
Okay.
The name?
Yeah, Paul Martinez, I'm sorry.
Okay.
Come on, you should be able to read my mind.
Can I get my camera, please? You want them at the table?
Please.
Mr. Martinez's cases are case number 22 CF 872, 20 CF 1961. Hello, Mr. Martinez.
How you doing?
Good, how are you?
Marty?
Yeah, this is Paul Martinez, and I know the court was just saying, his case numbers, he is present for sentencing. I do intend on calling 5 witnesses. I would like to start by calling Dr. Randy McDonald.
Okay. Dr. McDonald, if you please come to the stand.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yeah, before we start, I believe the state would stipulate that Dr. McDonald would be authorized to give her opinion testimony.
That's correct, Your Honor.
So, Doctor, do you remember how long your evaluation of Mr. Martinez took?
I wrote down it took 1 hour and 51 minutes.
Now, as part of the family history in that evaluation, your report references that both his grandmother and his mother suffered from mood disorders. Do you know exactly what kind of mood disorders he was talking about?
He had reported to me there was a family history of bipolar disorder and depression.
Is that bipolar? Is that a genetic, inheritable issue, or is that just something people randomly get?
There's often some genetic component to individuals having that condition.
What was the other one? Was it depression?
Yeah, same thing.
Same thing?
Yeah.
Okay. Now, Mr. Martinez disclosed to you during this evaluation you began using marijuana at the age of 12, correct?
Yes, sir.
And in your report, you quoted him as saying that the use of the marijuana stopped my brain from moving so much. That's a direct quote in your report, correct?
Mm-hmm.
Do you know what he was talking about?
So you described it as, sort of that just thinking all the time. Later in the interview, he talked about it seems like I just think just to think. So just kind of going from one topic to another, often, minutia type things. Why is the grass green? Why is the sky blue? As a kid, had a lot of trouble with inattention and restlessness and all of that. So he was just very easily distracted and unfocused, and so his thoughts would just, move around that way.
Are there any particular mental health conditions that would cause somebody to feel that way?
Several. ADHD, was one that you'll hear a lot of kids talk about. I can't stop my brain, I can't slow my brain down. And ADHD is attention deficit hyperactivity disorder. I have talked to people that have anxiety, so people with generalized anxiety disorder often have what we call apprehensive anxiety or expectations. They're just worried about what could happen, what has happened, kind of worst case scenario type things, and so their brains would just go over and over those kind of scenarios and thoughts. People with psychotic disorders sometimes have racing thoughts. People with mania, as in bipolar disorder, have those kind of thoughts. So it's a pretty common symptom, and when people report it, you kind of have to take a step back and sort of break it down into what it actually looks like and feels like, and how that may contribute to one diagnostic condition or the other.
Okay. Now, do you know why Klonopin is prescribed to people?
It's an anti-anxiety medication, so it's used to treat anxiety. I think it's also used for acute treatment of seizures. So if someone's having a seizure that can't be stopped, that can help with that.
What is Buspar?
Buspar is another anti-anxiety medication. I also see it prescribed a lot for folks that have bipolar disorder. In my review of why that is, it's an off-label use for depression.
Okay, off-label meaning it's not formally for that, but it's been found to treat that?
Yes, and it is often prescribed for.
Okay. Now, at what point was Mr. Martinez prescribed those medications?
He talked about taking those in the early 2000s. He had a primary care doctor that prescribed them for about 2 years, he told me.
And at the time that he was prescribed those, he was also using other substances, correct?
Yes.
The use of illegal substances, would that tend to diminish the effectiveness of the prescribed medications?
Well, it's certainly going to cloud, your understanding of how effective they are, or whether they're effective. We also don't know, is he taking them as prescribed or misusing them in some way. So, so certainly it's hard to say if he benefited at all from those at that time. Okay.
Fair to say then, because he's using other substances, it's kind of hard to get a gauge of how effective this is.
Exactly. Okay. Confounding variables.
Now, Mr. Martinez told you that he didn't start feeling depressed until after he started using drugs. Is that correct?
Yes, and he talked about kind of like in his early 20s is when he had his real sort of first major depressive episode.
Okay. But he also told you that he started using marijuana at the age of 12 to help slow his mind down.
Yes.
Is that right? Okay. What he was talking about, what he was experiencing at the age of 12, did that give you any indication whether or not he was experiencing mental health issues at that time?
It did. He didn't report just that. He talked about in school, he would get into trouble a lot for what we would probably identify as behaviors related to ADHD, so that not staying in his seat, getting in trouble, doing all the things he shouldn't be doing while he's in class, he's unfocused, not doing his work and all that kind of stuff. So when you have some reporting, your brain's kind of going, and then you're also seeing these behavioral expressions of that certainly makes one think ADHD. He talked about a school nurse and a counselor said to his mom he should be on medications for that condition. He was held back in the 3rd and 5th grades because of his behaviors, like they were so impairing, he had to do another year of those grades. So there are a lot of things there that are really hinting to someone having this neurodevelopmental disorder expressed as ADHD present early on.
Is it common for, I don't want to say common, but is it not unusual to see children that are suffering from ADHD have issues in school?
Absolutely. That's usually where it's first really picked up on.
Okay. Now, how common is it in your practice to deal with patients who present with complaints, I can't stop thinking, this is an issue, I can't turn my mind off? Is that common?
I would say very common. That's a common complaint. My brain races, I can't slow my thoughts down, I lay down to sleep at night, I can't stop my brain. So it's a really common thing that I hear.
Okay. Now, can these types of problems be addressed with medication, or is there a combination of medication and therapy that you would prescribe, or not prescribe, but recommend?
Right. Well, for any psychiatric condition, research is telling us that medications, when appropriate, coupled with counseling or other similar interventions, is going to be the most effective to manage conditions.
Now, in your review of the jail medical records, did Mr. Martinez request help for mental health reasons while at the jail?
He did. He was arrested and remained on suicide watch for the first, 17 days, and the notes indicated that pretty early on in that stay in the mental health unit, he was requesting help and specifically like a program of some sort.
Okay. Now, in your report, you used the phrase, and I'm probably going to say this wrong, labial effect. Did I say it right?
Labile affect.
What does that mean?
So it's like a rapid, sort of extreme movement between emotions. And so you might, I'm sure you've talked to someone who, one minute they seem fine, the next minute they're crying, they may be laughing, angry, so they're just going through a range of emotions pretty quickly and not for any real apparent reason. So that's what they had noted about him in the jail records.
Now, your report also contains the sentence, quote, on face valid screening measures of depression and anxious symptoms, he scored just within the severe range. Please translate that for layman's.
So within the records received from Dr. Banks, there was referral to these measures given. So the PHQ-9, I think it's called the Patient Health Diagnostic Questionnaire, I'm not quite sure, but it's a real kind of quick and dirty measure of depressive symptoms. So it's 9 questions. Face valid means that the questions, it's very clear what they're asking about. So it's, do you feel depressed more days than not, or something of that effect. And then the GAD is an anxiety version of that. So just a real quick measure of specific anxiety symptoms. And then based on the score they get for each item, they get an overall score, and that correlates to descriptive ranges. And so maybe within normal limits, low, average, above average, or extreme. I don't have them with me, I can't give you more specific, but basically the more symptoms you report, the higher your score is going to be, and the higher, the more severe the condition is believed to be.
Okay, so his responses to those 2 particular tests, for lack of a better word, is that he's just over the severe limit?
Yes, he was endorsing lots of symptoms of both depression and anxiety at that time, and at what we would call a clinically significant range based on those measures.
Okay. Now, do you know, while Mr. Martinez was being treated by Dr. Banks, do you know whether or not Mr. Martinez engaged in mental health treatment at that time?
So it was referenced in the records that I think he scheduled an appointment with Bridgeway Center, but I don't think that ever happened. I did ask him during the interview if he had engaged in any sort of mental health counseling as an outpatient, and he said that he had not.
Now, can depression fluctuate in severity?
Yes, I would
Okay.
say that's more common than not.
Can it go away naturally? Can you just?
Yes.
Okay. How often, is that common that it just kind of disappears, or is it more common to see like once it's here, so you're always going to be dealing with some level of it?
Yeah, it really just depends on the specific kind of depression someone has, because we have a variety that we can diagnose. You can have someone that has, a single episode of major depressive disorder. It's there for weeks or months, and then it resolves, and then they don't have any further issues. And then you have people that have major depressive disorder with recurrent episodes, and they could happen, almost on a cyclical manner. Every spring they may go through a bout, every fall they may go through a bout, whatever it might be. You can have persons that have dysthymic disorder, it used to be called persistent depressive disorder. So these are people that they have kind of a low-grade depression. It's there all the time. When I explain to people, I ask them to think about Eeyore, because Eeyore is just sort of kind of persistently depressed. And they may function their whole life like that, but they can also have major depressive episodes worked into that too. And so you can see them kind of functioning at this low grade and then have really severe dips and kind of come back up. They don't come back up to a normal, whatever normal is these days. They're going to stay at that kind of low grade persistent depression.
Okay. Now, your report references that Mr. Martinez indicated he was having feelings of hopelessness and helplessness. Are those two different terms?
Yes.
How are they different?
So hopelessness, would be just that feeling that things aren't going to get better. It's just, this is the situation I'm in, it's not good. Helplessness is more about how they perceive their ability to affect change in their situation. So if I go do this, is that going to make things better? Or nothing I do is going to make things better. So I always ask those questions because they're good indicators of depressive symptoms, but also just sort of, how are they perceiving their ability to affect change and make things better for themselves.
Are those clinical terms, or is that just kind of a...
a lot of clinicians use them. I wouldn't say that they're limited to...
Understood. Now, I don't know if you know the answer to this, but the use of illegal substances, street drugs, whatever the case may be, can that exacerbate depression?
I would say yes.
Okay. Would it probably be fair to say, though, that it doesn't always do that, though, right?
It is, and it really depends on the substances the person is using and how that substance affects them. So if you're using a central nervous system depressant like alcohol or marijuana or heroin, those sort of naturally slow the brain down, and they can, kind of exacerbate depression that's already there. For some people, methamphetamine or stimulants, like cocaine, can make them feel depressed. So again, it really just depends on the person and how they're affected by the substance.
Would it be fair to say that the whole issue of depression is very fact-specific to an individual? How they process it, how they deal with it, the feelings they have about it?
Yes, obviously there's genetic components, in terms of their predisposition to depression and how the body and the brain reacts when that happens. But certainly someone's perception of ability to deal with symptoms, access to treatments, and social supports, and all of that all plays a part in how it's managed.
Now, your report notes that Mr. Martinez suffers from stimulant use disorder, and then you wrote in the report that that was in sustained remission in a controlled environment. Does that mean that particular disorder is in remission because Mr. Martinez is currently in a controlled environment? Or is that it's in remission and he just happens to be in a controlled environment? What does that exactly mean?
So really it's just a notation that he's in a setting where access is presumably limited. For some people, their remission can be solely based on their inability to access the substance. But for a lot of people, they're in that situation. Maybe it is going around the jail, I don't know, but they're able to say no to it. So okay. It's just a notation that he's in a situation where it's not easily accessible.
Now, specifically in terms of Mr. Martinez, if he's not in a controlled environment, do you think that he's going to be able to control his impulse to use stimulants?
So at the time that I saw him, he obviously was sober, had been sober for a while, was clear-headed. He's very motivated to do different, and he thought he was doing better before he got arrested. So I perceived him to be someone that's very motivated to stay sober, certainly needs support and assistance in doing that, because his history would suggest that he, is at high risk for relapse, just based on how it's gone in the past.
Your report also has it looks like a provisional diagnosis of attention deficit hyperactivity disorder, predominantly inattentive presentation. What does that last part mean?
So there are, there's really 3 different kinds of ADHD. So you can have predominantly inattentive, predominantly impulsive hyperactive, and then a combination type. So at this point in his life, the symptoms he reports that are suggestive of ADHD are that predominantly inattentive presentation. So the hyperactivity, the restlessness, all those kind of things that he exhibited much more as a child, he's drawn out of, and that's settled down over time. And we see that with ADHD, where they get better behavioral inhibition as the brain develops and matures.
Does ADHD ever go away?
I think it's terribly overdiagnosed. So I think you see a lot of kids that are diagnosed with it and don't have it later. I don't know that they had it in the first place. You know, ADHD, like every other psychiatric condition, has a range of severity presentation. So you can have someone that has mild ADHD as a child. Again, their brain develops, they get more cognitively mature, they have better inhibition of behaviors and all of that. They develop compensatory skills, and you may see them not showing any symptoms when they get older. Whereas you have other people that have a really severe case of it, and they struggle their whole life with it.
Now, is ADHD, is that the type of condition that manifests itself early in life, or is it, can anybody get it at any point?
So ADHD is a neurodevelopmental condition. So to be diagnosed with it, you should have a significant number of symptoms displayed before the age of 12.
Okay. Have you ever heard of like adults just out of the blue being diagnosed with it?
Oh, yes.
Yeah.
That goes back to my theory of it being terribly overdiagnosed.
Gotcha.
It's not a theory, it's a fact.
And so your belief is that Mr. Martinez probably had ADHD as a child? Which...
I do, yes. And I'm a fairly conservative diagnostician, I guess. When I was younger, maybe I would have just said he has ADHD. But for me, I would want school records or maybe some collateral information from a family member that could say, oh yeah, when he was a kid, he was all over the place, he had trouble in school for not paying attention, et cetera, et cetera. But he does report a lot of symptoms, and there's some behavioral indicators that was what was going on with him at that age.
Now, your report notes that the ADHD that he has, quote, likely present since early childhood. What do you define as early childhood?
Well, if I'm going by the diagnostic manual, anything before 12. But again, for him, we have these behavioral indicators where he's having learning issues. They put him in special education classes when he was in 2nd grade. He had to repeat the 3rd and 5th grades because of his behaviors. So there's these indicators that at those ages, 7, 8, 9, and 10, he was showing problematic and likely symptoms of ADHD.
And he didn't start using marijuana until he was about 12?
That's what he reported.
Okay. Now, why do you think Mr. Martinez would benefit from being sent to the Phoenix House program?
So the residential program will offer him the ability to focus on treatment without the distractors of life, right? So for him, when he gets out in the community, he's around people using or faced with stressors that he can't manage, these may be triggers for him to relapse. So a residential program that just allows him to focus on him and what he needs to address, I think is ideal for him. It's a dual diagnosis program, so it's going to address both mental health and substance abuse issues. It's going to be intensive. There's going to be something going on every day that's therapeutic. So I think it just offers him this program and this opportunity that he's asking for to really sit down and address the problems he's had for a long time. Do
you think that Mr. Martinez is amenable to treatment?
I think so. I mean, again, in the jail records, right when he got there, he was asking for help. He was asking for a program. He wants something different for himself. He said to me that as much trouble as he's been in, and he's been in a lot, he's not been offered drug court or mental health court or any of those kind of things. So it seems like there was an opportunity that may have been missed for him. So I do think that he is open to that. We also talked pretty frankly about he's getting older. He's in his 40s, and he has a granddaughter now, and he really wants to be part of his granddaughter's life and not disappoint his granddaughter and his children anymore.
Is there anything that I haven't asked you about that you feel that the court should know?
I don't think
questions.
To the state?
I think you mentioned that so I just want to make sure, all of this is self-reported, right? Have you actually verified that his grandmother actually had mental health issues, or is that just self-reported?
It was self-report.
Okay. Does the things that you talked about, the ADHD and the depression, do those typically manifest themselves in people just not being where they're supposed to be at? I mean, how would that explain deliberately missing curfew and then going over to somebody else's house that you're not supposed to be at? Like, how would that affect those decisions?
Well, ADHD, I guess, could contribute to someone forgetting, where they need to be. Depression certainly affects someone's motivation and volitional behaviors when it's severe. So I'm not, when I did this evaluation, I didn't ask him how these conditions caused him to engage in behaviors, because it wasn't really a mental state.
And you said, and I just want to make sure, in the report you said when he was experiencing bouts of depression, he would isolate himself?
That's what he reported.
So he wouldn't actually, he didn't report that he would be with people. He said, when I was going through these bouts of depression, I would actually isolate myself and want to be away from people.
Yes, and when it got severe, he would sleep in his car and things like that.
So could you make the assertion that if he's around people, he's actually not experiencing those bouts of depression based on his self-reporting?
I wouldn't say he wasn't experiencing them. I think that for him, the depression probably starts out mild and gets progressively more severe, over a period of time. So I couldn't say for sure.
Okay. The last question I have, has Mr. Martinez ever been diagnosed with ADHD?
Not that I'm aware of.
Okay. All right, I have no further questions.
Can you redirect?
No redirect.
Donald, let me ask you a question. It may only be one. When I see in your report that it says that Mr. Martinez was offered a referral to mental health counseling but declined, apparently in early 2022. That's the third paragraph from the bottom on page 4.
Yes, sir.
Why shouldn't the court see that and say, that wasn't that long ago? He was offered that, he didn't do it. Therefore, the court doesn't find that he's amenable for treatment. He is just putting that on now because of this sentence.
I don't really have an answer for that. He went to Dr. Banks, and Dr. Banks offered medical marijuana for treatment of anxiety, and I think that was a substance he had relied on in the past that provided some relief for symptoms, and I expect that he thought that would be enough. And I say that because I'm seeing a lot of people doing that right now. They're going off their psychotropic medications, they're not doing counseling, they're relying on medical marijuana, because it is a pretty quick and easy fix.
Okay, so what I hear you say is that Mr. Martinez believed that the marijuana would be enough in early 2022 and he didn't need any additional treatment.
That would be my hypothesis. You would have to ask him for sure. The records I got were after I did the interview, so that was just a notation that I had within the notes that I got from Dr. Banks that he had been offered but had declined. So I did not follow up with him on that statement in the records.
Because one of the things that I look for is, I call it building up goodwill. I mean, I look for a track record and say, look, over this period of time, here is something that was very consistent with what you're advocating to. And all of a sudden say, I found Jesus in the jail yesterday. There's just not a lot of track record there. So that's why I'm asking that question. Because 22 isn't 2001 or 4, or, it's not a long time ago in the eyes of the court, but it may be infinite in your professional opinion. So I just wanted to know.
Yeah. In talking with him, he got out of Department of Corrections, he got a girlfriend, you know, he thought he was doing good, I guess, until he got into trouble. So I don't know that he viewed the symptoms as impairing as they had been in the past, maybe.
Anything else you want me to know?
I don't think so.
Do either of the attorneys have any questions for Dr. McDonald based on the court's question?
I just have one. And I think she may have said it. I think you may have mentioned this, but is it common for people that have problems, is it common for them to try to figure out ways to treat themselves or address the issue themselves?
Yes, I mean, I think most of us that have been doing work, you know, in this area know that it's easier to get illegal substances and medical marijuana than it is to get mental health help. So, you know, he may have had the ability to access and didn't follow through with it, you know, for whatever reason or another. You know, he's at one point he'd scheduled an appointment with Bridgeway and he didn't follow through with it. I don't know if it's because there was an arrest. Could he have made better efforts to seek treatment in the past? Absolutely. If you look at his history, he wasn't functioning well.
I don't know if there's an answer to this. Do you know whether or not marijuana has ever been attempted to be used to treat something like ADHD?
Formally or informally? Formally. I don't believe that it has been approved for treatment.
It kind of seems like it mainly affects kids, so maybe we don't
right.
put kids on.
Yeah,
Okay.
there's a short list of psychiatric conditions that have been approved as.
I just was curious. I've never really heard anybody say yes, it can help with ADHD or no, it can't. So I don't have any other questions.
No further questions, Madam.
Hey, Dr. McDonald, will be released.
Yes, sir.
Thank you so much, Dr. Yes, ma'am. Next witness,
John, I'm going to call Stephanie Martinez.
Ms. Martinez, if you please come to the stand.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Can you go ahead and tell us your full name?
Stephanie Marie Martinez.
And how do you know Paul Martinez?
We have been married for 20 years.
Okay. Are you guys still in a close relationship?
Yes and no, not currently. As a couple, we have always, it seems like when we broke up, we've always been more close. Like when we grew up together, we've been together since we were kids. So, you know, we're always there for each other.
Okay. Now, in the time that you've known Mr. Martinez, have you ever talked with him about potential having mental health issues, things like that? What do you guys talk about?
Over the years, I mean, when we were younger, and things were happening, I had a lot of mental health issues. So he would ask, you know, talk to me and want to know, like, if I always felt like he was comparing himself to me, like, to try to figure out if maybe that was what was wrong with him.
Right. Now, has he ever expressed an interest to you to get help for the problems that he has?
Recently,
Okay.
in the last few years, he has, you know, asked several times, you know, how to possibly get into a program or how to, you know, how to talk to somebody or, you know, for me to help make an appointment or, you know, anything, yes, in the last probably 3 to 4 years.
Prior to the last 3 or 4 years, we went in a time machine 10 years ago, would you have been talking to you about getting treatment?
No, he thought that I mean, like his medicine helped him. He thought that that's what he called it. I mean, he always used marijuana and he thought that it did help him slow down with racing thoughts and stuff like that.
Okay. Do you want him to get help?
Yes, sir.
What kind of help do you want him to receive?
I think he needs, I've done a lot of research on the Phoenix House, and I like the fact that they do help with substance abuse and mental health. I don't think just a drug rehab would do him justice. He definitely needs somebody to talk to and address the issues that he has and realize that he has them. So that's why, I mean, we've done a lot of research on Phoenix House.
Do you think he can succeed if he does receive treatment?
I think if Paul could realize what's really wrong with him and what he really fights and the demons, inside of him, I think that yes, I do. I know he could. I know both sides of him.
Is there anything else that you want Judge Brown to know prior to him imposing a sentence here?
I just want Judge Brown to know that, I know that it looks bad when he didn't accept the, treatment or ask for help before. But Paul is getting older and he wants a lot different. He knows that he's got an issue and he knows he has problems and he does want a lot different for his life. He has a granddaughter and one on the way. And I think we messed up a lot during our marriage and, with our kids. And he wants to show his grandchildren better than that. And I think that's why he needs help. I think that's why he wants to get help.
I have no further questions.
I have no further questions, Your Honor.
Ms. Martinez, how old is your granddaughter?
I got one that's 2, and we've got one that's due in the next 3 weeks. 4 weeks, about next month.
Thank you, ma'am. Any questions based on the questions?
No.
Thank you so much, Ms. Martinez. You can step down. Your next witness?
Did Janie Martinez?
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Can you tell us your name?
Jamie Martinez.
How do you know Mr. Martinez?
He's my dad.
Thank you, ma'am.
Do you know whether or not your dad has mental health issues?
I believe he does.
Would it be fair to say, as the daughter, might not be something you've had detailed discussions with him about?
I have really bad depression issues, and he's talked to me about some of the stuff he goes through. And so, yeah, I do.
Have you ever talked directly to him about getting help for his problems?
Yes.
How are those discussions go?
My adopted mom works with Bridgeway, and he's asked, how does it work? What do you do? Well, I go to counseling, I get my medicine. So he's brought it to my attention that he did want to get help and talk to somebody about what he's going through.
What kind of help do you want your dad to receive?
He needs to talk to somebody about what he's gone through in his life. He needs counseling, and I don't think that rehab will hurt him. I think it will help him as well.
Do you think that he could succeed if he receives treatment?
I think if he goes in there and tells them how he really feels, then yes.
Is there anything else that you want Judge Brown to know prior to him imposing a sentence here?
No, sir.
I don't have any further questions.
I have no further questions, Your Honor.
Thank you, Ms. Martinez. You can step down. Your next witness, Mr. Bond.
Tracy Martinez.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Can you tell us your full name?
Luis Martinez.
And how do you know Paul Martinez?
He's my father.
Do you know whether or not your dad has any mental health issues?
Same thing like my sister. I believe he does, just because some of the things that we have gone through and found in our counseling help. But as far as has he gone and been formally, I have no idea.
Gotcha. Do you want him to get treatment?
Yes, sir, 100%.
What kind of treatment do you think you could succeed at?
I think more so the mental health. Rehab is a big thing for my dad, but mental help is the help that he hasn't actually been able to receive yet.
Is there anything else that you want Judge Brown to know prior to him imposing a sentence here?
Just that my dad's not, a bad person. His ego may have gotten to him in the past, which I personally think is why he has never tried to go and actually receive the help. I think it was more of an ego thing. But like everybody's saying, this is my daughter that's 2.5. She was here, but she left now. He hasn't even had time with her, you know what I'm saying? And I think that just with the right kind of help, I think my dad can be the person that he needs to be, because I've seen my dad firsthandly when he got out of prison the last time. He moved in with me, and me and him did great together. He did a wonderful job. Over a year, me and him were able to, take care of the house. He was able to keep a job, have a car, and just do the right things in life. And it wasn't until after we left that house that he started to find himself into trouble again. So I don't really know. Again, I think it's more mental health rather than a rehab, because he's already had that kind of help before. He's already been to prison time and time again. And I don't see that that's actually going to benefit him where he is today. And my dad does have health issues as well as the mental health. And I would hate to see him go to prison and not be able to come home.
What kind of health issues does he have?
He has liver and kidney problems.
I have no further questions.
To the state.
I have no further questions, Your Honor.
Thank you, Ms. Martinez. You can step out and for being here.
Yes, thank you. Thank you for hearing us out.
The clients and the other witness.
Last witness I'm going to have, Your Honor, is going to be Paul Martinez.
Mr. Martinez, if you'll please come to the witness stand. Mr. Martinez, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. Please be seated. Mr. Clark.
Can you tell us your full name?
Paul Martinez,
How old are you?
42,
And what do you do for a living?
construction.
So what's your family situation right now?
Well, I'm married and have 7 kids.
Okay. Now explain to Judge Brown, what problems did you have in school?
We always get in trouble. Doing whatever I wanted to do instead of what I was told to do. Stayed in trouble more than anything.
Do you remember what grade you were in when you were 12 years old?
Fourth grade, maybe, 3rd.
And is that the age that you started using marijuana?
Yeah.
Now, when you were still in school, do you know whether or not anybody ever recommended that you be placed on medication?
Yeah, the guidance counselors, teachers, pretty much everybody, principals, school nurses.
Did they ever talk to you directly about this, or
They talked to my mother.
were you present for those conversations?
Yes.
Do you know if they ever encouraged your mother to address any ADHD problems?
Yeah, that's basically what I said. The day thought that's what I had, because I couldn't, I would never stay focused, I would never sit still long enough to do my schoolwork.
Were you ever placed on actual medication? Did your mom ever?
No.
Okay. Do you know why you started using drugs?
Well, the first time I ever really used drugs was because, I wanted to be like everybody else. Because everybody else was doing it. But once I started doing drugs, it actually, helped me, slow down and stay more focused on more things.
Okay. Now, you started with marijuana, right?
Yes.
Have you ever really drank at all?
Not like an everyday thing, but, socially.
Would you say that you're more, let me preface this, I firmly believe that alcohol is a drug. I mean, by definition it is, but there's always that alcohol and drugs. Were you more of a drugs guy, non-alcohol? Would that be a fair way to say that?
Yeah.
Okay. Now, at what point did you feel like your drug use was kind of getting away from you and kind of becoming something you couldn't control?
2010, 11.
All right. How old were you when you first used methamphetamine?
19, 20.
And what happened the first time that you used meth?
The very first time I ever used it, it made me feel normal, really. I could actually think about one thought at a time instead of because my mind is always thinking and running, and it just stopped that. It made me feel like I could function.
Did it keep you up for days at a time?
No.
Okay, so
I could actually, because everybody else would be, if I got high with people, they would be moving around, and I would just, be sit on the couch. I could watch a movie and focus, go to sleep, wake up the next day, go to work, whatever.
Are you asking the court to help you figure out your problems with illegal drug use here?
I know I have a problem with drugs, and I believe that the drugs, I use drugs to help me function, I guess is the right word. Because whenever I'm not on drugs, I'm all over the place, scattering, can't hold a job, you know what I'm saying? So I'm asking for more of the mental health thing. Even if,
Let me ask you this. Did you ever feel like you were using drugs to try to medicate yourself to deal with the mental health issues that you were dealing with?
Yeah.
Okay. Now, have you ever been suicidal?
Yes.
Is that a recent development?
I've thought about it, before, but more so now, I guess.
Do you know why you've had those feelings more so now?
Because I had to get sober.
Okay. Have you ever experienced hallucinations? Okay. What kind of, tell the court, we know that you at least made an appointment with Bridgeway. Have you ever done anything else to address the mental health problems before you got in trouble this last time?
No. Because I would start using and I would feel better. So I figured if I just get high, I won't have these problems.
So would it be fair to say that you didn't try to address the mental health issues because you had an easy way to try to deal with them?
Yes.
Okay. Since you've been in jail, have you had access to methamphetamine?
I mean, no.
So you've been sober since you've been arrested?
Yes.
Has that kind of opened your eyes to, I need to address the underlying issue here?
Yes.
Okay. Has anybody ever offered you drug court at any point?
I haven't been, I mean, I've been evaluated for it, but I have never been, like, offered it.
Okay. What about mental health court?
Same thing.
Okay. Are you asking this court to sentence you to a treatment program?
Yes.
Why?
Well, I mean, I've been to prison, obviously, 3 times, and I keep getting out and doing the same thing. Once I get out, I mean, I'm good for a little while, and then I start using instead of getting the proper help. So, I mean, if I can get help with the problem that I have, maybe I'll stay out of jail, prison.
Do you think you could succeed at a treatment program?
I have to.
Why do you say that?
Because if, I mean, this is where I keep coming back tired. It's gotta help. Now that I know that I need to tell somebody what I got going on, and they can help, maybe that'll help.
Is there anything else that you want Judge Brown to know prior to him deciding on a sentence here?
No, sir.
I don't have any more questions.
This thing.
No questions, Your Honor.
Thank you, sir. You can step down.
No more witnesses, Your Honor, just arguing.
Any evidence from the state?
No, Your Honor.
I do have one piece of evidence, Your Honor, if I may approach.
Yes, sir.
Your Honor, this is Defense Exhibit A, which is a Phoenix House acceptance letter.
Yes, sir. Any objection to that one?
No objection, Your Honor.
It's in video.
Your Honor, Mr. Martinez is asking the court to consider placing him in the Phoenix House program. He has been in custody since his arrest on April 1st, 2022. He is before the court for sentencing. He does score a minimum prison sentence of 52.95 months. The defense is asking the court to downward depart on the basis that Mr. Martinez suffers from a mental health condition that is unrelated to substance abuse, and he is amenable to treatment. Briefly, Your Honor, and I know the state had mentioned this in their letter too, there is a suspended 5-year prison sentence in 20 CF 1961. But the defense is going to be asking the court to revoke and terminate his prior supervision in 20 CF 1961, place him on a new term of 3 years of probation, with the special condition that he attend and complete Phoenix House. I would think that Mr. Martinez would have probably no problem with the court even modifying or deleting the suspended sentence in that particular case, so that the court would have the full range of punishment if there's a future violation. That's a second-degree felony, so he would be opening himself up to quite a lot more punishment, potentially, if he violates. In 22 CF 872, the new case, I would, on the DUI count, ask for credit for time served and just D6 the license and put the minimum requirements, the fine, and the DUI school. So he'd have to do that to get his license back. On count 1, that's the fleeing and eluding. I'm going to ask the court for 3 years of probation. Concurrent to the 1961 probation, there was a mandatory 1-year driver's license suspension. Again, the special condition being Phoenix House and court costs. Your Honor, put simply, Mr. Martinez, he's not unique, unfortunately. Dr. McDonald described everything that she did, especially when it came time to talk about his childhood, said everything that he dealt with in school was indicators of ADHD. Mr. Martinez testified directly that he was present when school officials recommended that he be placed on ADHD medication, and his mom never put him on it. Unfortunately, it's a very common thing. As kind of went through my head. I said, you just described my daughter, pinging around and all that. The fact of the matter is he has a brain that needs to be addressed. And I think his daughter, I think she made a great statement, and I don't know why it's never occurred to me like this, but ego stops a lot of people from being able to step back and say, this is kind of embarrassing, but I need help. That's one of the reasons why Alcoholics Anonymous, is because it's supposed to be like nobody here knows who's here except unless you're here. It's a very touchy subject to individuals, and you don't find yourself in a position like Mr. Martinez is in now overnight. As the state more than brought to the court's attention, he's got a long history of criminal record. As a matter of fact, I think the police report in 22 CF 872 specifically references 19 prior felony convictions. Going through his prior record, Your Honor, 11 of his prior felony convictions are for grand theft under $5,000. Every one of those cases is from Pasco County in 1997, when he was 17 years old, I believe. He was definitely a minor. There's also a dealing in stolen property conviction from the same time period. He has 4 more convictions from Santa Rosa County in 2011, and that's when he served 6 years in prison. So of these 19 prior convictions that were mentioned in the police report that are on the score sheet, these prior felony convictions, 16 of them either occurred when he was 17 years old, or they came out of Santa Rosa County in 2011, for which he did 6 years in prison. And I don't say that to try to excuse it, just to try to put it in context. It's one thing, in my opinion, it's one thing if you see grand theft here, and then 2 years later there's another one, and there's another one 2 years later. If you get arrested all at one time, in my opinion, that should be treated as a one-time. That's one incident. Now, he's been incarcerated since April 2022. He's pretty much, sounds like he's tried to find every drug under the sun to deal with what the underlying issue is, and that underlying issue is an untreated, unaddressed ADHD type issue here. It's a mental health issue. I'm unaware of any case law that says that there has to be a formal diagnosis for a mental health issue. It just says, the score sheet just says mental health issue unrelated to substance abuse. It doesn't say mental health diagnosis. Everything that Dr. McDonald described sounds to me like it's classic ADHD. Of course, his problems are compounded by suicidal thoughts. Frankly, in the new law violation, during the deposition, I believe the officer testified that Mr. Martinez drove his motorcycle into oncoming traffic lanes. There was no traffic on the road. But he had also told Dr. McDonald, and I know the court had read her report, that he basically was driving around that time period trying to get pulled over because the intent was to kill himself. We're dealing with an individual that has significant mental health issues, who unfortunately has taken him quite a long time to acknowledge to himself that he's got these problems. He, previous to even being in trouble in this case, he was talking to Dr. Banks. He made an appointment with Bridgeway. I certainly understand the court's concern about, he declined, possible assistance, but Dr. McDonald also said that pretty frequently, and it happens. The way I treat mental health situations, like persistent mental health situations, is kind of like alcoholism, in the sense that it's always going to be there unless somebody gets to it. It's not like alcoholism, because that's never going to leave, but if you constantly are having problems and you're not addressing what the cause of the problems, you're just putting Band-Aids on it, then you're going to keep putting Band-Aids on. You're going to keep buying them, essentially. But it's like alcoholism in the sense that somebody has to hit rock bottom before they can acknowledge to themselves, and that's the first step, really, in any sort of an issue. When you've got, what am I doing? What can I do? The first step is to acknowledge to yourself, I've got problems, and I can't fix this. So it's taken him a long time to get to that point, but it takes everybody however long it takes them to get to it. It's a very individualized process to get to the point where you can look in a mirror and say, there's something I need to do. And it happened for him when he was 41 years old, 42 years old. It might happen to somebody else when they're 50. Some other people can recognize it and deal with it when they're 22. Mr. Martinez testified today, at the age of 12, he was in 3rd or 4th grade. He had been held back for 2 years. He left school, as Dr. McDonald, and this is all self-reported, but he had left school in the 7th grade. He hasn't even been around school in a long, long time. And that's a really, really young grade to just leave school. There's so much that you learn after the 7th grade in school to just kind of say, I'm out of here. At the 7th grade, right off the bat, that puts somebody in a disadvantage in society. He served time in prison before. I don't ever like to make the argument that prison's not working, Judge. Well, I'm fully aware that the statute says punishment's the main reason here, But it still says, that same statute says that incarceration, corrections is still a goal of the system, It's still called the Department of Corrections. And Mr. Martinez is constantly finding himself in trouble because he's not addressing the issue that's putting him in trouble, and that's mental health issues. Exacerbated and compounded by obvious illegal substance abuse issues. This is what Phoenix House is made for. This is exactly the type of program that he needs. And this is why Phoenix House, in my opinion, is different than any other program, because it specifically addresses the two issues that seem to put quite a lot of people in criminal courtrooms in the state. And so I'm not asking the court to do anything extraordinary here. I'm not asking the court to put him out, let him have, just put him back on regular probation and let him do outpatient treatment. I don't even know how long the wait time is for Phoenix House right now. But he obviously would stay in custody until he goes to the Phoenix House program. We believe that the defense has met the burden of proof for the court to grant a downward departure. It's a preponderance of the evidence burden of proof. And I will turn it over to Mr. Gomez.
All right, Judge. First, just kind of want to talk by going back through. So in 4620 CF 1961, that was an underlying case that is now a VOP in this case currently. At that moment, when that case occurred, the defendant actually went back and looked. The defendant actually scored the lowest permissible prison sentence.
I thought I only had 2 cases that are performed. 872 and 1961.
Yeah, that was the one I was just talking about.
Okay, good.
In 20 CF 1961, the defendant in that case actually scored 42 months as the lowest permissible prison sentence in the Department of Corrections. The plea agreement actually contemplated, it granted leniency to the defendant in 2 different ways. On one way, it actually dismissed 1 count of the possession of a firearm by a convicted felon. And then it granted leniency more so in that it provided to an avenue for Mr. Martinez to avoid a Department of Corrections sentence and place a 5-year suspended sentence. That agreement was entered into on December 31st of 2021. Within 5 months, on April 1st of 2022, the defendant was arrested on a charge of DUI, fleeing and attempting to elude law enforcement officer and resisting without violence. Unfortunately, just by those 2 examples, the defendant shows that he's not going to listen to this court. He doesn't have any interest in listening to the court. Furthermore, I just want to talk a little bit about some of the things that were discussed today. I think one of the most important things that has to be highlighted here is that at no point could anybody actually tell me of a diagnosed mental health disorder that Mr. Martinez is suffering from. The only thing was that he had some indications of ADHD. And I think defense counsel actually brought in a little personal anecdote, so I will myself. I've actually been medically diagnosed with ADHD. You don't find me getting really drunk, going and turning down suspended sentences, going and fleeing and attempting to elude law enforcement officers. You don't see me doing any of those things. ADHD is not one of those medical, and I tried to ask Dr. McDonald, how does that present itself in the context of these charges, and she couldn't do it. That's because ADHD isn't necessarily, doesn't affect a person's ability to make a decision of, oh, I shouldn't go and drink and drive, I shouldn't avoid this police officer when I have lights in the back of my mirror and things of that nature. I also want to focus on, in her report, it says in 2022, I mean, that's not long ago. In 2022, he declined mental health treatment. And she couldn't give you an answer as to how he's amenable now all of a sudden but at that point in time, he wasn't. He thought he was doing, there was a statement that he thought he was doing good before he got in trouble. So that actually points to, he felt like he wasn't actually suffering from mental health issues. And I asked the question specifically about the depressive state or the reported depressive state of the defendant. The defendant self-reports that when he's in this depressive state, which by all accounts, the depression would more greatly impact the decision-making process of an individual more so than the ADHD would when it comes to these charges. He says, I wanted to be alone, I would sleep in my car, I didn't want to be around people when I was depressed. I think that those things don't necessarily align with what was going on when he's found drinking and driving. The depressive state doesn't necessarily speak to those charges. I also want to point out, Mr. Martinez seems to be surrounded by people who are seeking treatment for their own mental health issues, and he's still not able to come to that decision himself that he needed that help before any of these events happened. Because as we said, in 2022, he was offered mental health counseling, and then he denied it. He has talked to his daughters who are actually in counseling, and he's still, asking, what do I need to do, and actually making the steps to make that happen are two very different things. And so there hasn't been any indication that he is amenable to any treatment up until the point where he was faced with this incarcerated prison sentence. I also want to point out, I know the record was kind of talked about and how the majority of it was back in Pasco County prior to 2011, but another important thing that was talked about, in 2011 he was incarcerated for 6 years, which means that he got out in 2017. From 2017 onwards, in 2020, he was convicted of a felon in possession of a weapon. That also happened again later on in 2020. He's also since 2011, felony DWSR, burglary. So it's not like he's just been this beacon of acting well and being a contributing member of society since that 2011 date. He did have a large amount of charges prior to 2011, but that criminality has continued consistently. I mean, he was in prison for 6 years, and then when he gets off, and within 3 years he has another conviction for that weapon, for the felon in possession of a weapon, and then he gets another one in 2020. To me, the statement that we don't need an actual diagnosis to meet that burden, in order to find a downward departure, if we open that up, then everybody is going to be, everybody is going to be alleging certain mental health characteristics that would allow them to satisfy any sort of mental health condition. Mental health conditions are diagnosable for a reason. It's so that those people can take those diagnoses and seek the appropriate treatment. In this situation, the defendant has not been diagnosed with a single mental health disorder. It is merely self-reported statements to Dr. McDonald, in which when I asked her, has he been diagnosed with ADHD, she said, no, not to my knowledge. So we're in this situation, Your Honor, where we have this 5-year suspended sentence that was granted and given to the defendant to provide him an opportunity to toe the line, to make the right decisions, and to be a valuable and contributing member to society. And then within 5 months, he catches these new charges. And so for those reasons, and for the reasons stated both in my letter and for the argument that I just made, the state is going to request that 5-year suspended sentence be lifted and the 20 CF 1961, and then in case 22 CF 872, sentence the defendants to the guideline minimum of 52.95 months in the Department of Corrections, because as it's been stated and argued here, there hasn't been a valid reason for the downward departure. Furthermore, just to make sure that we're clear, and I want this on the record, the state has agreed that any incarcerative sentence that could be imposed would be concurrent, and so the state would also be agreeable to that as well.
Thank you. Mr. Vaughn?
Your Honor, the statement that he hasn't been formally diagnosed with any mental issues is belied by Dr. McDonald's report. She diagnosed him with major depressive disorder. The provisional one was the ADHD. However, the conditions that she explained, what you would see with ADHD and what he granted, self-reported, that's what you see with ADHD. And I know, and I get why people throw around the word self-report. Well, psychologists and psychiatrists aren't mind readers. Like, they have to work, probably half their practice involves tell me what you've been going through. That's the whole nature of what they do, you know? So I would say that he has been diagnosed with a major depressive disorder, and that the evidence does establish by preponderance of the evidence that he suffers from ADHD. And so that's I do agree with Mr. Gomez that if we just came in here and could throw up anything, I mean, then everybody's going to have a problem. But that's not what we have here. We have a doctor, we have a psychologist who has evaluated him. The statement that she relayed about him turning down treatment, that was not to her. She testified that was from Dr. Banks's records. So she doesn't even know, she couldn't tell the court exactly what the circumstances were behind turning that down. But now we're back to the easiest thing in the world would have been for Mr. Martinez in this particular case to turn around to the state and say, let me limit the amount of time that I have to go to prison. He's already been to prison for 6 years. He's been to prison, I think he testified for another year, or maybe somebody else did, I can't remember, sometime back in 2007 or 2008. And I get it. And that's 72 months, and that's a long, long time. And I don't think anybody's made the argument or even hinted at the fact that Mr. Martinez is a beacon of society. I mean, the man has had a lot of problems in his life. A lot of it has been caused by drug abuse, which is being engaged in to address mental health problems that he has not ever addressed. So I strongly disagree that he's just looking for the easy way out. He's basically asking the court to sentence him to an inpatient program, and he's going to sit in jail for who knows how long until he goes. So I believe that the defense has met the burden of proof. I believe that the court can and should depart. I would ask the court, and last thing I'll point out, Your Honor, and I don't know if you want to look at it, this is the actual plea agreement from the VOP case. The only terms on here is 5 years probation, 5 years DOC suspended and court costs. There's no treatment. It's not like he was given an option or a requirement that he do treatment as a condition of that. It was just straight, here's 5 years of paper, and if you mess it up, it's 5 years in prison. So he's asking the court for help. And it takes everybody their own path to get to that point to be asking for help. But the type of help he's asking for is not, let me out of jail and I'll go deal with this on my own. It's, let me stay in here because I need to figure this out because he's only 42.
Does the state have a score sheet?
Your Honor, we can provide.
I'd actually printed up a clean score sheet, Your Honor.
Please.
Yes.
First, to the family members, please, to the wife, the daughters of Mr. Martinez, the court's ruling is based upon everything that's before me. So I don't want any of you to leave and think that I sentenced a certain way just because of your testimony. Because I don't. I take it into consideration with other evidence, and I just want you to know that that's not a burden you walk out the door with. Mr. Martinez, very difficult. When I was doing my homework, I really just said, I've got to make this decision when I come to court, and I've got to listen to everybody. There wasn't any, I think I'm going to do this, or I think I'm going to do that, subject to what I hear, which is a lot of times what I think when I come in. I have a pretty good feeling about what's going on. In your case, I really didn't, because I wanted to hear the evidence, hear the doctor's testimony. I'm really glad that she testified. I agree with Mr. Kleins that you've been diagnosed with major depressive disorder, but the doctor didn't testify a heck of a lot about that and how that relates to the actions that you've taken. And in order for me to downwardly depart, I've got to be able to connect the diagnosis. And so here's what I have to find. The defendant requires specialized treatment for a mental disorder that is unrelated to substance abuse or addiction, or for a physical disability, and the defendant is amenable to treatment. But I believe that that has to relate to the crimes that are committed. Just to say you fulfill that requirement and pull that out of the air and it doesn't have anything to do with what the crimes are, It doesn't make sense to the court. A lot of discussion about ADHD. I agree that was provisional. I don't believe that the court can hang its hat on and say, because of ADHD, the court can narrowly depart because the actions that Mr. Martinez did were because of ADHD. Your testimony, Mr. Martinez, was very credible. And that's one of the things that when I was doing my homework in my chambers, and I look at all, especially defendants' faces, and I have to determine credibility. You know, is Mr. Martinez going to do what he says, what his attorney is advocating for him? Very credible. You didn't say, I'm going to do this, I'm going to do that. You said, if I get the proper help, I may be able to step out at prison, or basically avoid prison. Your daughter used the word ego. When you were testifying, I wrote down the word proud. You can just see that pride in you, but not an arrogant pride, just you're comfortable with yourself, but you don't like those actions. And so, again, I think you have a lot of credibility. There's no way that I'd say you're not credible. I believe what you said. So I do find that you have that major depressive disorder. I don't find that there's evidence that shows that's why you did the actions that brought you before the court. I know that's not technically what the statute says, but I think there has to be some connection between the mental health disorder and the actions that were taken. And I say this to put this on the record, because if I'm wrong, I want the appellate court to tell me I'm wrong. So based on that, I find that I cannot find a reason for a downward departure. You're adjudicated guilty. Your prior supervision is revoked and terminated. You're sentenced to 52.95 months in the Department of Corrections with credit for all time served. That's on each count. And other than the misdemeanors, which are time served, that's for each count and case. There's more than one case, so it's a $250 public defender's fee. It's 2 VOP cases, correct? Just one. Just one. $100 VOP fee. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost in the other case. There's a $500 fine for count 2 of the 872. The state's letter has 2 different court costs, one for count 1.
Well, because one was a DUI, so I think those court costs are actually mandated, if I'm not mistaken.
Yeah, so you get the $548 for count 1 because the fleet only would also get the misdemeanor DUI.
Okay. Yes, ma'am. Those are imposed. 6 months driver's license suspension. Mr. Martinez, you have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, sir.
Thank you, sir.
Any further?
Your Honor, before we proceed, can I step out in the direction with the court? It'll be very quick.
Figure out how to get, okay, who's on Zoom, that's wearing the backpack shot. And then I'll see if I can get Mr. Bird, what's the number, telephone number, we can have on here. Set with the number. But now we don't. Allison, you don't know the number for the restaurant, do you? There used to be a sticky. A number for, well, there's a telephone number on the Zoom.
Send me guys a number to call.
So call the Zoom telephone number. Okay, first let's see where's the early index.
I don't have anything else, I have excused.
Yes, sir, thank you.
Call the Zoom telephone. Okay, can you hear me now?
I can, Mr. Burt, can you hear us?
Yes, sir, I can.
Excellent, we couldn't hear you before, and so it was very frustrating. That's why I asked you to take it off mute before.
Well,
we were trying.
This dumb old man here had his headphones plugged into his laptop.
There you go, okay, good, well, that makes me feel better. So, Mr. Burt, you're here because you want your pistol back, correct?
Well, I would like to have it back if the court will allow that. My wife and I, when I retired from Navy, we sold the condo in Dexter and bought a house up here in Holly. So we're kind of out in the woods, and there's a lot of animals, bears and coyotes, and I've got a little dachshund, and I'm afraid something's going to get her, and all I have right now is a BB gun.
Yes, sir. So let me ask the state if they have an objection. And if they do, then I want to know what criteria I have to find to grant or deny your motion. Yes, sir.
Your Honor, the state does have an objection to this.
Okay, tell me why.
Our reason for the objection is, well, first and foremost, the forfeit subject weapon was specifically delineated in the plea agreement. That's the first reason. So this was agreed upon by the defendant. The second reason, in the motion it states that his wife was panicked while he was trying to show her a pistol. The report clearly states that post Miranda, the defendant admitted to removing, and I'm just quoting, the defendant admitted to removing his Ruger LCP handgun bearing serial number 371770740 from its holster during a verbal altercation with the victim. The defendant said he raised the firearm and engaged a laser while the victim was seated outside. The defendant did admit to waving the firearm approximately 2 feet to 4 feet from her. The state understands that the victim submitted a drop charge request, but that drop charge request doesn't say this incident didn't happen, or didn't say I don't remember quite what happened, I don't think it went down that way. It literally said, we just felt like this was out of character for him. That was what the victim stated. And so for those reasons, the state doesn't feel comfortable giving this firearm back, given the allegations that was in the report. The fact that the drop charge request doesn't say that those didn't happen, it just says it was out of character. And then thirdly, and most importantly, that the forfeiture of this weapon was a specific condition of this agreement. And while I can't speak to the mindset of the state attorney at that time, I know now, generally speaking, if you're not going to forfeit the weapons, we're not going to offer a plea agreement like what we did. And so for those reasons, we would respectfully request that this plea agreement remain honored and that that firearm remain forfeited. Thank you.
Thank you. Mr. Byrd, I did read your motion. I read through that. One of the things that we learn in law school is that the court can't change the terms of the contract. The court can't just say, I'm going to impose my will on you when you two did a contract that said something. An exception to that is if somebody's on probation, even if the state and the defendant enter into a plea agreement and it says 4 years probation, the appellate courts have said I can change the terms of that plea agreement, which is contrary to changing the terms of the contract. A plea agreement is a contract. I don't see the forfeiture of the firearm as being a term of a probation. So I think that I would be changing the terms of a contract, and I don't think I have that legal right. So respectfully, your motion for return of your firearm is denied. Thank you, sir. Thanks, Mr. Burke.
All right, thank you.
Yes, sir. Okay, now the other gentleman that's on Zoom.
This should be Mr. Brandon Bradley, Your Honor.
Mr. Bradley?
Yes, sir.
Okay, where is Mr. Bradley? Mr. Bradley, okay. Mr. Kleins represents Mr. Bradley.
It was a first motion, Your Honor, so.
Yeah, this is.
Oh, okay. Let me check it out. Motion to terminate probation, Mr. Bradley, right?
Yes, sir.
Good. Mr. Bradley, do you want to testify? You want to give me some evidence?
I mean, yeah,
Okay.
I just clearly seen the evidence.
Hold on.
What you can.
Okay, hold on. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Now put your hand down and tell me why you think I should terminate your probation.
Well, I've been holding down a job for like 2 years. When I went to prison, because I was sentenced as a juvenile when I was 17. So when I went to prison, it really kind of showed me that I don't really want to live that type of life. You know what I mean? So since I got out, I violated with it was like a weed charge, but it wasn't my weed, it was just in the car, so I wasn't even telling my friend, so, but I moved away from Walton. I moved in with my dad, got my own place. I held down a job for 2 years. I really don't, I do everything on the terms, you know what I mean? I paid all the fees, I've done classes, and I go to probation, I check in, I leave in like 5 minutes because it's like, well, we did everything, so, you know, it's like, he really told me to do this.
Okay. To the state, do you have questions?
No, I don't have questions for the defendant, Your Honor.
Okay. Okay, so argument from the state?
Your Honor, we would respectfully deny this motion to terminate probation. I believe this was entered into in 2019. He then actually violated his probation. And so for those reasons, once he violated his probation, that next agreement for us is one of those, we contemplated that agreement knowing that he had already violated, we'd given him a chance. And so we want to make sure that probation is seen all the way through, particularly with given these charges. These are rather serious charges. And so the state would request that he be required to complete the full range of his probation. Furthermore, when I actually I discussed with Mr. Bradley, if I'm not mistaken, with probation, they actually couldn't even give me a recommendation because of his violent felony offender status. And so for those reasons, the state would request that the defendant be required to complete his full term of probation as contemplated by the violation of probation agreement that was entered into when he violated his first.
Okay. Was the violation of probation solely for marijuana possession?
Let me check your order. Yes, Your Honor, he had committed a new law violation of misdemeanor marijuana possession.
And how long is Mr. Bradley, how much longer does he have on probation?
I believe it terms in September of 24.
October 26th of 2024.
So, I mean, given that he hasn't even reached, I don't think his 2/3 point, so.
A year and a couple of months, a few months?
Yes, sir.
Mr. Bradley, you said you're in school and you've been working?
Yes, sir. I go to HCC and I work at Outback Steakhouse.
And how many hours do you work?
I work every day except for Monday.
And how long each day?
I do, on Wednesdays I work nights from like 4 to 10. Thursday, Friday I do doubles.
Thursday and Friday, what? Doubles?
I do doubles on Thursday and Friday.
And then how many hours of classes are you taking?
I'm doing prerequisites right now, so I'm waiting for school to start in August, so I'm not hitting like on break right now.
So you're taking high school classes?
No, I graduated in prison. Like I did GED in prison, but I'm going to school for engineering, but at college.
Mr. Bradley, because the violation didn't relate to firearms, didn't relate to violence, because of what you've accomplished since you've been out, your motion to terminate probation is granted. So your probation is terminated. Is he up to speed on all his financials? Or?
Yes, sir. He's completed everything and everything's paid.
Okay. Mr. Bradley, your supervision is terminated.
Thank you.
Thank you, sir. Okay, what's next?
That works for me.
I have a sentencing.
I think it's the only one's left.
Did we get to John Matthews? So, Madam Clerk, who do you have left?
I have Jessica Smith. I have James.
Okay, wait, Jessica Smith, what docket was she on?
2:30.
Okay. Yes, she was on the change docket.
Do we want to do Jessica Smith? She's in
Yes, ma'am. You got it, please?
Okay, Jessica Smith.
And the docket says sentencing, but I didn't see anything on the docket that gives me any homework.
Yes, Your Honor, if I'm not mistaken.
You don't need to go into the substance of it, let's get her, but I
Oh, no,
just
this
wanted
is
to
it.
make sure if you go, no, here's all this stuff.
It's, yeah, no.
Just to, yes, she's coming out. And also we have that one from the morning docket, Arrowwoods.
Right. Okay, good, thank you.
Judge, Ms. Smith is before the court in 23 CF 1082 and 21 CF 339. Your Honor last saw Ms. Smith via Zoom on Monday. And the reason why the quick turnaround is we did not want to enter a plea and to be sentenced over Zoom on Monday. Your Honor doesn't have a sentencing letter from the defense or from the state. We were not able to turn around that quickly. So we would be relying upon testimony here in the courtroom today. Because this conversation was had over Zoom, I did go back and prepare a written plea agreement, the same plea to the bench, no agreement with the state terms. If the court wanted to go through the colloquy again, just to make sure that we're covered on the record.
Good.
I believe, Your Honor, I believe we started the colloquy over Zoom.
And is there a score sheet for that, Ms. Smith?
Your Honor, the state will have to provide one.
I believe I can provide it.
I know that she doesn't score.
She doesn't score?
She does not.
That's the main, okay. Ms. Smith, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, Amy. So, Ms. Smith, are you currently under the influence of any drugs, alcohol, or medication?
No.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, Your Honor.
How far did you go in school?
College.
Did you read the plea agreement?
Yes, Your Honor.
Do you understand it?
Yes, Your Honor.
Did you discuss it with your attorney?
Yes, I did.
Did he answer all of your questions?
Yes, he did.
Are you satisfied with his representation?
Yes, I am.
Did you sign the plea agreement?
Yes, I did.
Do you understand that if I accept your plea, that you're waiving your right to a trial by jury?
Yes, I did.
Has anyone forced, threatened, or coerced you into entering the plea?
No, sir.
Has Mr. McKinney or anyone else told you, Ms. Smith, if you don't enter this plea today, you'll be sentenced to 5 years in prison or any other definite sentence?
No, sir.
Ms. Smith, and you understand that you could be sentenced up to the maximums on here, to a maximum of 12 years in prison?
Yes, sir.
Ms. Smith, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you and are represented by competent counsel. Are you satisfied with Mr. McKinney's representation?
Yes, I am.
Of whom you state you are satisfied. I do find factual basis. So sentencing, Mr. McKinney.
Judge, to give the court kind of a framework in what the sentencing is likely going to entail, since the court doesn't have a sentencing letter, there's no need for downward departure based on the score sheet. Ms. Smith has a new charge of driving while license revoked, and which is the 23 CF 1082. That is 1 count information, 3rd-degree felony. She's also on probation in 21 CF 339. That was a 3-year probation term that started in July 2021. The defense argument is going to be asking for the court to grant her another shot at probation. Ms. Smith does have family in the courtroom that wishes to address Your Honor, and I'd like to call them to testify very briefly. May Ms. Smith be seated at council table?
Yes, sir.
I'd like to start with Ms. Smith's mother, who's present in the courtroom.
Ms. Smith's mother.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
And would you please state your name for the record?
Rosalind Boutiette.
And how do you know Ms. Smith?
She's my daughter.
Can you point to or explain to the court a change in your daughter's behavior when she was placed on probation?
She's been doing great. I mean, she's working, she's trying to start a business. The only problem is the transportation issues.
Is that, have the transportation issues been a problem for Ms. Smith?
Yes.
And you say that Ms. Smith is out and doing well related to starting businesses. Have you seen her try to do better from when she's been placed on probation?
Oh, yeah.
Do you believe that she's doing better in the community now since she's been doing this probation as opposed to prior to her being placed on probation?
Yes, absolutely.
So do you think that the probation has been helpful for Ms. Smith?
Yeah.
Is there anything else you want Judge Brown to know about your daughter when he makes a decision for sentencing today?
Well, her record looks much worse than she actually, she's not like that. But, and she's already gone to prison for this entire time. I can understand why, when she thought how she wasn't getting her driver's license back then. So she started all over again. She would just give her license back and let her move out of Florida. She'd do just fine.
Now, you understand, this court, it's not the DMV. We can't order somebody's license back. But if the court were to grant her more probation and using its discretion, are you going to be in a position to look over your daughter's shoulder just like probation would be to make sure that she follows the law, including driving with or without a license?
I'm not sure.
Are you going to be in a position?
She's almost 40 years old.
Are you going to be in a position to help?
Yes, I'll help her.
Okay. I have no further questions.
Did you say questions in the letter?
No further questions, or no questions, no.
Thank you, ma'am. You can step down. Thanks for being here. Mr. McKinney, your next witness.
I don't know if I can say Crystal's last name.
It's LaPred.
LaPred.
Can you raise your hand, please? Do you swear or affirm the testimony about the truth,
And could you please state the name for the record?
Crystal LaPred.
And could you please spell your last name for the record?
LaPread.
How do you know Ms. Smith?
We've been friends since I was like 18.
And what do you want Judge Brown to know about Ms. Smith that has brought you to be here in support of her today?
That she's done like a complete turnaround. Like she follows everything except for this one, it's the driving. But I mean, she started a business, she was going to school, well, she became a paralegal, and now she's taking like all the different classes to like target on different areas. But she started like a business with these, where she sold coffee beans, she has a clothing business, and she's just trying. Like her mom said, the only thing that she really is limited on is, you know, being able to move around. So as a friend, like I help her whenever I can to get to and fro wherever she has to go. But
Were you a friend to Ms. Smith prior to her being placed on probation in this latest period?
yeah, we've been friends since 2007.
Do you think that this period of probation has been helpful for Ms. Smith?
Yeah. This is like the time period where she's actually been like sitting down and like focusing on growing herself as a person and more self-love and like helping her kids like develop everything that they want to develop in life. She's really been focused on like fixing everything that she messed up, fixing everything that she wants to like build for the future.
Do you know anything about Ms. Smith's brother?
Yes.
Can you explain to the court what happened to Ms. Smith's brother?
You mean like how he died?
Did he die very recently?
Yes, he just died before the 4th of July, I believe it was, or on the night of I think July 3rd is when that happened. But the funeral was actually tomorrow in South Carolina, so like that's why I'm dressed like this and hit the road.
Is that service planned for tomorrow in Charleston, South Carolina?
Yes, at 11 o'clock in the morning.
Do you know where?
It's at the Greater Macedonia AME Church. Y'all need the address? I don't know the exact address.
Is that where the celebration of light and the interment is going to be in Charleston, South Carolina?
Yes.
Are you going to be going to that regardless of whether Ms. Smith is in a position to do that or not?
Yes, that's why I'm dressed like this, so I'm ready to get on the road. Just want to make sure she can come with me.
Now, is there anything else that you want Judge Brown to know specifically about Ms. Smith before he makes a decision on sentence today?
No, I mean, I think I said everything, but I just like want you to know that she really has improved and she is trying. She's been like completely like different person. And she's always been there for me with everything that I've ever gone through. And even more so now, like, because she's like basically just slowed everything down and like focused on friends and family.
I have no further questions.
I have no questions, John.
Let me ask you this question. You said that she's completely different. How was she before?
We were always going out to the club and stuff like that. So like she's just more of a homebody, more focused on her studies and doing things with her kids.
And how long has that lasted? How long has it been since she's changed?
Since she got the deed that originally we further to her probation, like since then.
Do the attorneys have any questions based on the court's?
No.
No,
Thank
no.
you, ma'am. Thanks for being here. You can step down.
Banks?
You swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Could you please state your name for the record?
Isaiah Banks.
How do you know Ms. Smith?
She's my mom.
Can you tell the court whether or not you believe that this period of probation has been helpful for your mother?
It really has, because she, like Crystal just said, she used to go out to the club a lot, and me personally, I never liked that. But ever since she went on probation, she really has been trying to change. She was staying at the house, focusing on her lawyer stuff, doing her coffee beans, and trying to sell her clothes, but she don't have transportation. But yeah, she really has been trying to change.
Are you in a position to help your mother with transportation at all?
I don't have my license, so I can't really. I mean, I could give her Ubers and stuff, but that's about as far as it could go.
And I guess what I'm getting at there is transportation an issue for a lot of people within your family?
Mm-hmm.
Is that a yes?
Yes, sir.
Okay. Who does Ms. Smith take care of at the house?
She takes care of me. Well, I used to stay over there, but now I be back and forth between Dothan and Fort Walton, so I don't really be in Fort Walton with her as much now. So, yeah.
Is that primarily because Ms. Smith is incarcerated?
Mm-hmm.
Is that a yes?
Yes, sir.
Okay. And how old are you, sir?
I'm 17.
Okay. Is there anything else that you want Judge Brown to know about your mother before he makes a decision in sentencing today?
She really has been trying, and I know her track record may make it seem like she's, been bad all her life and just always messing up, but she's really trying. I can see it in her and I can feel it because we feel me through the phone and the way we talk with each other now. It's completely different than how it used to be. And I really hope that she could get out. That's it.
I have no further questions.
I have no questions, sir.
Thank you, Mr. Banks. You can sit down.
Is Roderick still there?
He had to go to work.
Okay. Ms. Porter?
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes,
Ma'am, could you please state your name for the record?
Valerie Porter.
And how do you know Ms. Smith?
Me and her have been very good friends since for about 13 years now.
And you're obviously here in support of Ms. Smith today.
Yes, sir.
What do you want Judge Brown to know about Ms. Smith as he makes a decision in what the proper sentence should be?
Judge Brown, I've watched Jessica for a long time. Like, I've seen her rough. Everything that they're saying on her background, that's not the person that she is today. She has totally changed. Like, my best friend has really changed. I'm so proud of her. And I really want her to know that, And I just feel like this time, has she really learned a lesson? And she understands that she don't need to be driving anymore to make any careless decisions like that because it could take her away from my family, and everybody, a lot of people depends on her, she's good in the community. She helps me and my kids with all my kids' school projects and everything, I really hope she, learned a valuable lesson this time, and I hope everything turns around for her today.
I have no further questions.
Yes, ma'am.
I have no questions, Your Honor.
Let me ask you one question. So how long in time have you seen the change?
Well, to be honest with you, the last time that she went to prison and came home, I started seeing it then. I started noticing it just over the months and the years, she just totally changed.
How long ago was that? She got out of prison?
If I'm not mistaken, it's 3 years now. I'm going on 4 years now. And she did a whole turnaround. She doesn't be in the streets anymore. She she just don't do none of the wild stuff that we used to do together. And, you know, she's home, she take care of her family, and she wants better. Like, she's very dedicated to her businesses. She's upset now about her paralegal stuff. She thinks she's gonna fail at that because of this, you know. And, you know, she's really been trying. She really has.
Yes, sir. Any questions based on the court's question?
No, I have no questions, no.
Thank you, ma'am. You can step down.
Judge, because Ms. Smith has family here, may she be allowed to read a statement from the witness stand?
Yes, sir, absolutely. Ms. Smith, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. Please be seated.
I'm just going to say it out, but I wrote it down just in case I get emotional.
Okay.
But it says, Your Honor, before coming to jail on this particular driving without a license charge, I thought I was doing no wrong. Not because I have a direct disrespect for the law, but it was because I honestly thought I was doing it for my family. After countless efforts, thousands of dollars, and fulfilling all the requirements over the years in order to obtain a valid driver's license, just to receive a letter resuspending it within a 30-day time frame, each time I did, was very discouraging. I even motioned the courts in 2019, asking my sentencing judge at the time to waive financial obligations to help me get a valid driver's license in cases that had it suspended before my release from prison on March 3rd, 2020, which was granted by Honorable Judge Stone. The first few months after my release, I dedicated to following the necessary steps with the DMV. I waited a long time for the Administrative Board of Review to give me a hearing and was denied in spite of all I had done, and was left with the impression that it was an indefinite denial for a hardship license. I saw no way out, and being a single mother and having to take care of my children and my household, I thought getting behind the wheel was my only option to provide, and I justified my actions with those reasons for a long time. But Your Honor, today I look at it differently. Everything I told myself that I was doing it for, I actually put at risk. My family, my home, my goals. It's very disappointing that it took so long for me to come to that realization, because I could have saved everybody some heartache along the way. You know, I'm aware of my history and what's in that black and white. Every bad decision I've ever made is in front of you. And I paid for them dearly in more ways than just in this courtroom. You know, but I was in a very dark place in a long time, you know, battling my traumas and my addiction, and I got stuck there for so long. But Your Honor, I'm different today. A new and better version of myself is here before you. That person in your files no longer exists. At my bond hearing, you stated that I sound like an overachiever, which has never described me before. But an overachiever is who I certainly aspire to be every day, because I wasted so much time doing the wrong things. And I want to make it right. I want my kids and my parents to be proud of me. I have so much to prove to my family, to myself, and you in this courtroom. When I caught my original charges that put me on probation, it triggered a major wake-up call in my life. I knew I no longer wanted to be that person, because that is not who I truly am. I have turned my life around tremendously during this time. Before I violated, I've enrolled in multiple certification programs and graduated 2 of them, as well as enrolled in schools to continue my education. I've started multiple businesses that I'm attempting to nurture and grow from the ground up, and with time, effort, and consistency, it can turn into something great for my family. I have completed the majority of my requirements on probation and have remained drug and alcohol free the entire time. I'm at the mercy of the courts, asking that you consider these things and reinstate my probation and allow me the chance to continue to grow into a better mother, a better daughter, and a better person, and let me back with my family where I belong, because they need me just as much as I need them. And that's it.
Mr. McKinney, any other questions?
Ms. Smith, one of the things you stated there was that you've worked on completing the conditions of probation.
Yes.
In the 21 CF case that you're on probation for, Have you completed the DUI school yet?
I've paid for it twice, but with my conflicting scheduling, I wasn't able to do it because it's a whole week long from like 5 to 9:45, Monday through Friday. But that's the only thing that I haven't done. I've done everything else.
So that's something that you still have to do for the 21 CF case.
Yes.
I have no further questions.
To the state.
I have no questions, Your Honor.
So you were released from prison when?
In 2020, February. March 3rd, 2020.
Thank you, ma'am. You can step down.
Thank you.
So any other evidence?
Yes, they have none, Your Honor.
I have nothing further, Judge. Just
Pardon
arguing.
me?
Judge, the court does not have to do a downward departure reason in this case. The court has the discretion to sentence Ms. Smith to probation in the 23 CF case, which is a driving while license suspended. And the court has the discretion to reinstate the supervision in 21 CF 339 if the court so chooses. The probation officer, one of the people closest to Ms. Smith, recommended that her supervision be reinstated and be modified to community control. They asked for a suspended sentence. I'm not asking the court to do that, but that is the recommendation of the probation office. Ms. Smith does have criminal history. She has a prior record, and everybody acknowledges that. But Ms. Smith, from when I speak to her and when I speak to her family, I know that she is a productive member of the community. She is a big part of her family, and that she's a big part that's missing right now. So the easy route for Ms. Smith would be to say, I don't score state prison. Give me some county jail time and let me off probation. Ms. Smith doesn't want me to ask for that. Ms. Smith wants me to say, I can do these things, that I can complete probation. I want the court to look over my shoulder. I want more supervision because this has been working for me. What, did she drive when she wasn't supposed to? Absolutely. Did she get caught up in trying to provide for her family? Yes. She certainly understands now, after this time spent in jail since May, that her actions have consequences. But instead of asking for county jail time or a reduced sentence to revoke and terminate supervision, Ms. Smith wants me to ask for a probation period that's concurrent in 23 CF 1082, and for the
How
court
much time is left on that?
in 21 CF 339.
July 19th, 2024.
July 9th, 2024 is her termination date that's scheduled for 21 CF 339. The court obviously has discretion to reinstate, extend, modify, any of those things. The court has the ability to revoke and resentence to a completely new term or different term in this situation, that we're not talking about downward departure reasons or score sheet issues. The court has a wide toolkit of what it can choose to do here. The state is likely going to rely on Ms. Smith's criminal history, her prior record, and asking for a incarcerative-only sentence to revoke and terminate and get Ms. Smith off of probation. My opinion is that if this has been working, if this is something that the court has heard from the friends and family, that they have seen a turnaround in Ms. Smith's behavior, that's a good thing. And that's something that Ms. Smith is asking me
Yes.
to ask the court for reinstatement of probation to make sure that she finishes it out.
Thank you. To the state.
Your Honor, I'll try to keep this relatively brief. I think Your Honor is well aware that generally speaking, the state doesn't seek incarceration when it comes to charges such as HTO, DWSR, things of that nature. However, when you go through this defendant's history, I think since 2004, I counted 16 DWSR charges. It becomes an issue when it's recurrent. And part of the reason why it becomes recurrent is because there hasn't been any mechanism with which to hold her accountable for that. Furthermore, when the state is looking at DWSR charges, if it's strictly financial reasons why a person is HTO'd or why they have that DWSR, we approach that in a vastly different manner. While a lot of these situations tend to be financial, this particular one, the 2 DUIs played a role in suspending that license. And so for those reasons, given the fact that, you know, she was actually on the VOP, she was given a charge of HTO, and she's more than aware that she shouldn't be driving. I think we heard testimony that multiple people would have given her rides. They actually testified to that today, that, you know, we'll give her rides. Well, why didn't they give her rides then? Why didn't she get those rides at that time as opposed to?
I don't remember any evidence of that.
There was,
One person said that
there was testimony.
that he didn't have a license.
Right, that was her son. There was 2 people that testified that they would help get her from point A to point B. My point in saying that is when they did testify to that, they could have gotten her from point A to point B at this instance. And so there's multiple other opportunities. Her son actually pointed out to Uber. There are so many different ways to get around from point A to point B nowadays in 2021 or 2022 and 2023, not aside from just friends and family, that when we look at this, the state feels compelled to request an incarcerative sentence. At this time, the state is requesting 12.1 months in the Department of Corrections. That is entirely based off of the 16 prior DWSRs, the 2 DUIs, the counts of reckless driving and careless driving. It's gotten to the point where the defendant needs to be held accountable. She was out on probation when this happened. She got this charge again. There's nothing that's been presented that's, you know, points to the fact that she's not going to do it again. There's 15 other reasons actually that point to the fact that she's going to. And for those reasons, we would request a 12.1 months DOC sentence.
Thank you. Ms. Smith?
Yes, sir.
One of the last things that Mr. Gomez said was there's nothing to point to that you're not going to do it again. The witnesses that you called, your friends and your mom, but your son stands out. First off, when he said he was 17, he carries himself like he's much older than 17. He's very articulate. I just wrote down the word secure. He seems secure with himself. Certainly all of your witnesses, very credible. They didn't hesitate. They're telling you the truth, telling you what they feel, what they've seen, what they believe, and I believe them. Certainly have concerns about your past, but I do find that there's a reason to believe that you've changed and that you will change. You being out since March of 2020, the things that you've accomplished, the time that you've spent on that, you just can't drive until you get a license. You just can't do it. You know, you being in jail in May and June, I take that into consideration also. Based upon everything that I've heard, the evidence, you're adjudicated guilty, you're sentenced to credit for time served, and that's followed by 6 months community control, followed by 2 years of probation. However, your supervision will automatically terminate after the first year of probation if you've successfully completed all the terms of your supervision and haven't committed any new law violations. I want to give you that extra impetus and drive. The original terms and conditions are reimposed for that time, so the term is revoked, terminated, but the original terms are reimposed. It's to run concurrent between each case and count. When I say that, I hesitate. Are there any counts that it wouldn't run because they're misdemeanors or anything like that?
Those were previously time served.
Time served on misdemeanors.
And that was previous in the 21 CF case?
Yes.
Good. Ms. Smith, I wish you the best. Your drive in business, again, I remember when you walked up, your face and all your jobs that you have, everything that you've accomplished, and the love of your family and your friends, them here all day waiting for this, waiting to get out of town. Don't let them down, okay? Thank you, ma'am. So, Ms. Smith, you're going to your brother's funeral?
Yes.
I believe she'd have to have the court's approval to do that because of the community control.
She'll have to check in tomorrow morning since it'll be, she won't be released till after 5, so she'll have to be at the office at 8 a.m. and I can't guarantee that she'll be in South Carolina by 11.
How can I waive that? What about if I put her on probation until some period of time after she can get back from her brother's funeral?
And the court can do what the court wants.
Okay. So, I don't know exactly how.
Can the court delay her report date if today is Thursday to next Monday?
We have a deadline to get address verified in 48 hours, so we would have to verify it tomorrow or Saturday once she's on community control.
Is that because of the community control sanctions or the probation?
So, Ms. Smith, you're on probation for the next week, okay? And then after that, your 6 months of community control starts.
And if you could put on the minute sheet that you grant her permission to go to South, she'll still have to check in tomorrow, but after that, she can go.
She can check in by phone tomorrow, okay? She's gonna be on
That's
the road.
fine. Okay.
So just call, make sure you keep it between the lines, until this is over.
And the court would need to announce court costs.
All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. There's a $100 VOP fee, $250 per offender's fee, $40 per month cost of supervision. Again, the supervision runs concurrently, runs at the same time. Okay. Thank you. And I'm sorry about your brother.
Thank you very much. I appreciate it. Thank you, Judge Brown.
Thank you again to the family and friends.
Your Honor, I have RS Marquez and the
Yes, ma'am. Here, thank you. Okay, you're standing there alone again.
Yes.
I did ask over lunch, I asked my judicial assistant to call and find out where Mr. Arrowwood was. I believe what she told me, at least in the hospital, and maybe in intensive care.
He's in South Florida, Your Honor, and I reached out to his clerks as well. And we're in a tough spot because I think, from my understanding, the misdemeanor case got resolved.
Yes.
And I think we're in a position to where I can resolve this. The only issue is that I can't contact Mr. Arrowwood.
What is the offer?
Yes, ma'am. Hold on, let's check in.
First off,
What
is this?
It is 2019 CF 1687.
19 CF 1687. 87.
So now technically, since that's resolved, basically what I would want to do is add 6 months of community control to this 19 CF 1687. The CT case, I believe, was handled. And so my offer would be a modified probation to add 6 months of community control.
When you say add, does it convert 6 months of the probation to community control?
No, I would like an additional 6 months of probation on top of what's remaining.
Okay. And then there'd be a $100 VOP fee?
That's correct, Your Honor.
Be it. Right. Have you ever been on community control before? It's a house arrest.
No, but I can do it.
Okay.
Judge Plea,
Please.
as a friend of the court, do you have any questions about what community control is? What you figured out?
Like, you have to check in and basically write everything out.
You have to follow a very strict schedule. You cannot deviate from that, especially when you go to work and come home from work.
Okay.
Based on the your schedule, stuff like it would be 2 trips to burgers.
Yeah.
That's not going to be that kind of violation. Very strict. You have to follow it. Be very serious about it.
Okay.
So you have to
So, Mr. Harris Marquez, everybody in here, we understand, you know, the challenges that Mr. Airwood has, but we also understand you're in a jump seat, and you've appeared in front of me multiple times in the past. I went back and printed the minutes 2 times ago. Mr. Airwood wasn't with you. The last time, at least the minute says he was. I don't know. If you want to basically waive your attorney being here today, very, very unusual. I've never said that before. But as long as you know what you're getting into and that you're waiving the advice of your attorney, since you'd be getting out of jail today, do you wish to accept the state's offer?
Yes, Mr. Your Honor.
Okay. Was he previously adjudicated guilty in the past?
No, I would maintain the withholding.
Good. If you'll raise your right hand, do you swear to tell the truth, all the truth, and nothing but the truth, so help you God?
Yes, Mr. Your Honor.
Thank you, sir. You can put your hand up. So do you understand that if I accept your plea, that you're waiving your right to an evidentiary hearing, basically a judge trial, where the state would have to prove the violation of probation against you? If you say it out loud.
Oh, yes, Mr. Your Honor.
You can keep your hand on it. You also understand that you're waiving your right to an attorney?
Yes.
Have any questions about, here's what I'll send you to, withholding adjudication? Your current supervision would be reinstated with all the original terms that you had when you went into the jail, except you have an additional 6 months of community control, and you have to pay a $100 VOP fee.
Okay.
Okay, is that what you wish to do?
Yes, Mr. Your Honor.
I do accept adjudications withheld. Current supervision is modified. Original terms are reimposed to add 6 months community control, $100 cost of prosecution. Okay.
Okay.
Thank you, sir. Good luck to you.
Thank you.
Yes, sir.
Good day.
Thank you, sir. Okay, Madam Clerk, you said you had a couple of...
Yes, I have Mr. James Williamson was on the docket for competency
James Williamson.
I represented Mr. Williamson in 22 CF 2231 at his
tomorrow morning at 8 a.m. Should we think of that?
competency hearing about 6 months ago. The court set a status just to see where he was at. There's not been an update from Florida State Hospital yet. He is still at Florida State Hospital. I think it would be appropriate to take him off of the docket until we have a status update from Florida State Hospital.
Okay, so shouldn't I get an update every 6 months?
You should.
And has it been more than 6 months since the last update?
It's been more than 6 months since the court found him incompetent to proceed. I cannot say that he's been at Florida State Hospital for 6 months because there's some lag time in people actually getting into Florida State Hospital after being found incompetent to proceed.
Do you want to prepare an order that directs them to give that update within 30 days?
I can certainly do so.
Okay. Why don't we do that and then schedule to see him on August 24th at 9 o'clock. And if he needs to appear via Zoom from the hospital, we can do that.
Yes, sir. So that's August 24th at 9 a.m.? Yes, sir.
I also have Tyler Clayton Hale with Judge Fairwood. That was set for 9 a.m.
See you.
It was set for 8 a.m.
I mean, I don't recall us ever calling that, so I'm actually being a nice state attorney, and I'm not inclined to ask for a KPS because I don't really think that we ever called that name. That's my only concern, is if he was here in the courtroom, we didn't call the name. Like, I don't want to issue a KPS and then he get picked up and then we find out, well,
So you want to just continue it?
yeah, I would rather continue it, given the circumstances of Mr. Airwood. I'd rather not.
It's continued until August 17th at 9 o'clock.
Can I get the next name, excuse?
Yes, ma'am. Thank you so much.
Thank you.
Thank you.
On the 130, Randy Dock, I have Michael Henry Johnson Jr.
Michael Henry Duncan Jr. Yes, ma'am. Number 1, 23 CF 1380. It was scheduled for 1:30. He wasn't present, it's 5:05.
State request the case, Your Honor.
Case will be issued for Mr. Duncan. The first appearance judge will determine it.
And I also got the number of the dog, Kaiser and Thames.
Sorry, what's the last name?
Thames.
Thames. And it's pro se?
Yes.
Yes, okay.
State request the case, Your Honor.
23 CF 1161. Yes, sir, a case will be issued for Mr. Thames. That it? Great, thank you, Madam Clerk.
Thank you, Judge.
Thanks, everyone.
All right.
You're good, go about your business, I'll clean up mine.
Can't wait for Monday. Yeah, it's gonna be the greatest thing ever.
I know.
I missed it. I got travel weekend. I missed it because I didn't know about it. But now,
Yeah, I'm going to.
I'll probably still get an email, but.
Probably still, but I think that's clear as document. Tell somebody that call.
They come right up and just set up.
I would have Saturday, but I'm pretty sure we'll get.
Yeah, from a specific person.
But I know.
Yes, so I get an email every 4 days.
Me too.
Every 4 days, and I'm like, it's not on the issue. We need them in. No, you don't, because it wasn't enough.
Yeah.
I can't laugh deeply because I'm very wrong, but I feel as though I got to do this big joke about hours. And I tried to laugh at my mom.
You had that good party,
I don't know if you heard it, but it almost smells just like the go over. Going over the people that are like,
He was a stripper. I said, sorry, man, you know, what about the size of the
bronchitis.
He said, well, my routine is I go to my patients before I put my
Yeah, my daughter just decided to give it to me.
her hand was cold.
Bless you.
She was scared.
You don't like being in court.
I started out to shred, and then, yeah, I was like, well, that sucks, you know? And I had the immune system.
You're scared of me in the doctor's office.
And
So they're scared.
you know, so I was like, well, I'm gonna make sure I didn't get that.
Yeah.
she was scared.
She was getting bronchitis.
Oh, yeah.
My daughter got bronchitis and shred, not shred,
And that was just neat.
That's scary.
yeah. Pretty much the only one in my house getting sick.
I thought
She's got a good immune system.
It's hard.
Maybe she's highly, I don't know, I'm kind of a baby. She's sick.
I think most men are.
Yeah, we don't do sick.
We don't find
Right.
It's tough.
I get sick and it's just like, I'm dramatic.
I've never done another one, I can't imagine.
I'm literally one of the ones I never can.
Well, good talk.
Great seeing you. Thank you, sir.
I'll be here next week.
Okay, sure, see you then.
That sounds like me. Not the other part, not the, you're the antibiotic, because I don't know.
Oh, yeah, okay, so like, listen to me, okay, I had probably on my birthday last year.
They're one you're talking about, yeah.
On my birthday last year, I had UTI, I was so bad, I had a fever, I had to go to urgent care, okay? I get home, I fall asleep on the couch, he gets home from babysitting or whatever,